Ms. Maxwell, are you ready?
Yes, I am.
Okay. So I want to welcome everyone to the June meeting of the Tennessee Real Estate Commission. At this time, I'll ask that we all come to order and that phones be silenced, please. And I would ask our Executive Director, Caitlin Maxwell, if she would read the public disclaimer for us.
Okay. Notice of the June meeting of the Real Estate Commission, including date, time, and location, has been noticed on the Tennessee Real Estate website since November 3rd, 2022. Additionally, this month's agenda has been posted on the website since Friday, June 9th, 2023. Now for the roll call. Commissioner Joe Begley.
I know he's on the way. He left the
Yes.
hotel before I did.
We'll note when he arrives.
Okay.
Commissioner Jeff Diaz.
Here.
Commissioner DJ Ferris.
Here.
Commissioner Steve Gwynn.
Here.
Commissioner John Moffitt.
Here.
Commissioner Joan Smith.
Here.
Commissioner Stacy Torbett. Commissioner Kathy Tucker. Chair Marcia Franks.
Here.
You have a quorum.
Thank you. Okay, at this time, I'm going to ask Ms. Tolbert if she would to lead us in a prayer and the pledge, please.
Bow your heads. Dear Heavenly Father, I just thank you so much for the opportunity to be here. Thank you for safe travels for those of us. Ask that you be with us today. Please stand. I pledge
allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Commissioner Tolbert. At this time, would anyone like to make any amendments to the agenda? Did we want to make an agenda for, I see we have a special guest here. Do you want to, okay, we'll wait? Okay. So no other agenda changes?
Motion to approve.
All right, all those in favor say aye.
Aye.
All those opposed? That motion carries unanimously. And now let's move on to the approval of the minutes. Any edits or changes or additions that we need to make to that? All right, we have a motion by Ms. Smith and a second by Mr. Moffitt. All those in favor say aye.
Aye.
All those opposed?
I'm abstaining.
Okay, Mr. Glenn was not, he was way far away. We're not exactly sure where he was. He told us, but we've never heard of that place. So we're glad you're back safely, Commissioner Quinn. Okay, and let it be noted, Mr. Begley is here with his Dunkin' Donut coffee.
Joe runs on Duncan.
We're glad you're here, Joe.
The traffic was a little different on that back road.
Okay, so I know it's a little early for the informal appearances. Do we know, are those appearing today?
Yes, let me check and make sure who's here. I see Scott Chapman on the line. Can you hear us?
Yes, I'm here.
Okay, is your principal broker here as well?
Yes,
Yes,
I'm here.
Nathan.
This is you.
Okay.
Nathan Weinberg.
Okay. And then let me just make sure the other is here as well. Jay Brooks.
Yes, I'm here.
Okay. And then your principal broker is with you as well. Yes.
That's correct.
Okay. Okay. If you guys are ready, we will proceed a little bit earlier than scheduled. And we will first review Scott Chapman.
Okay, good morning, Mr. Chapman. Are you there, Mr. Chapman?
Yes, can you hear me?
Yes.
Hello?
Okay, can you hear us?
Yes, I can hear you.
Okay, we're going to go ahead and get started. And how this works is we're going to let you tell us what you want us to know about your application. and what got you here today, what you've been doing since this happened to you, and also why you want to get a real estate license. I did want to say, though, that this applicant did not fill out the application.
I didn't fill out the application, you say?
He did not.
What was the application? I filled out an application for decision that was sent to me. Was that?
Let me see if it's just
was there another one?
a potentially it's a PDF transfer issue.
Okay. Because we don't have a
okay.
statement. We don't have a statement from him or the application. We have an application, but it's empty, and he signed it.
Okay, Aaron is confirming that it was completed, so I think it could have just been when it got sent to you.
Okay, so we're going to need to go over some of these questions since the commissioners have not had time to review your case, Mr. Chapman.
Okay.
All right, so what was the exact charge with which you were actually convicted?
I was convicted for possession of cannabis in the state of Florida.
Okay. Have you ever had any other discipline from any state or federal licensing agency?
Yeah, previously when I was like 3 years prior to that, when I was 20, I was convicted of the same charge, possession of cannabis in the state of Indiana.
So, I'm not sure that one isn't within the time frame.
Okay. Okay.
So I think we should probably proceed as normal with me going over the.
Okay.
And then we could
Fill in
print
the
out
blanks.
If
We
yes.
can fill in the blanks once he. Okay, that's fine.
It should be do you see the document for the Circuit Court of the 10th Judicial Circuit for the state of Florida and Polk County?
We do see that.
Yes, so that's the only document that you'll be looking at. So any, Mr. Chapman, any other convictions outside of that will not be for consideration today, so you don't have to answer any questions related to that. So we'll just be talking about the Florida cannabis felony conviction for possession over 20 grams.
Okay.
So, Ms. Maxwell, if you would give us a little scenario of this applicant then, please.
Yes. Okay. Before you have applicant Scott Chapman and his principal broker, Nathan Weinberg. Mr. Chapman has taken and passed the affiliate broker exam. The firm is MW Real Estate Company, and the summary of the criminal and disciplinary sanction is a felony of cannabis over 20 grams. Mr. Chapman's statement and a letter recommendation can be found on the iPad.
Okay, Mr. Chapman, if you would go ahead and tell us what you would have us to know about this case, please.
Yes, when I was in Florida, I was traveling playing music, and I had I was possessing cannabis, and I was in my car, and an officer came up to me and could smell the cannabis and proceeded to detain me and prosecute me. And since then, I've gone through the steps to go through the court process, and I completed my probation just fine here in Tennessee, and all that's been completed and okay, and I've been on just a better path since.
Okay, so when did this happen? What year?
This happened in 2021, 2021 April.
Okay, and so what have you done since that time to better yourself? Or I heard you say you were a musician.
Yes. Currently, my profession is a musician here in Nashville, and I've been doing that for 4 years successfully. I've got my own business doing that, and I've been grateful to be doing that full time. I have been working on that as well as my real estate education to get my real estate license, which has been a big goal of mine for the past few years. I've also just organized my life in a way of surrounding myself with better people and better hobbies to live a clean, healthier life.
So I noticed that on your on that legal document that we had, that you were not to be around any alcohol except as a musician. Are you a traveling musician or just based in Nashville?
Both. We travel and we primarily play a lot of local gigs here in Nashville.
Okay. So you've got that all under control?
Yes, ma'am.
Okay. So why do you want to have a real estate license?
I want to have a real estate license because I want to be more in control of my finances and my life and my success. And I think it's a great way to be involved in the community, to help others out, and not only buying and selling homes, but property investments. It's definitely an interest of me to learn about this industry and to use it for my benefit and as well as the community's benefit.
And how did you find, and what do you know about the company? Let's see, what company are you with? MW Real Estate Company.
MW, MW actually helped me and my family buy my first home here in Nashville a few years back. I think it was about a year and a half ago. And when I was interested about taking my first steps to get started in real estate, I talked to one of the brokers at MW and told them that I'm interested in getting my real estate license, and they said they'd be interested in having me there at MW. So naturally, I knew a couple people there at MW, and naturally it was just a great place for me to start my career.
And is MW located in Nashville?
Yes.
Okay, so what kind of real estate do you hope to be involved in?
I would love to get started in residential real estate, buying and selling houses for people in the community, and I'd love to work in my way into property investments and commercial real estate.
Okay. So at this time, do any of the commissioners have any questions for Mr. Chapman?
Has he taken the test? Excuse me. Since our form is not completed, can you tell me if you've already taken any of the exams?
So that's on the
yeah.
very first the very first page. That's under my statement that he
has taken it and passed the affiliate broker exam.
Okay, sorry.
That's okay.
Yes, I've taken it and passed.
And I was just going to confirm that he did submit the completed document. He did the fillable version, and for some reason, Aaron, when Aaron and I were doing the redactions, we're having trouble with Adobe, and so I think it stripped what he filled in. So I can happily answer anything that he completed if necessary.
I think we're good so far. Okay. Thank you, though. Okay, so now we want to talk to your principal broker, Mr. Nathan Weinberg. Good morning, Mr. Weinberger. Is it Berg, Weinberg?
Good. Berg, that's right.
Okay.
Good morning.
Okay. So if you would, sir, let us know how you know Mr. Chapman, what your plans are for him at your company, and a little bit about how you plan to train him.
Sure. Well, I appreciate the opportunity for us to sit in front of the commission today, and always appreciate y'all's very hard work, so thank you. We've known Mr. Chapman since we represented him in the purchase of his own home, and that was something that I had just sort of a tertiary connection to, though my business partner and also one of the brokers at my firm worked very closely with him during that process. And since then, we've been just communicating back and forth as Mr. Chapman has pursued his real estate license. And he has gone through all the steps. He's taken all the classes necessary. He's passed his tests. And so now we're in a place where we're excited to begin his training. And at MW, we have a formalized one-on-one training program. And so Mr. Chapman will sit directly with me on a weekly basis as we go through all of the forms the Tennessee Association of Realtors has created and provided for us. And then in addition to that, we talk about the tools and trade sort of principles that exist in real estate. I've been a real estate agent and broker in the Nashville area for over 15 years now. And my passion is training and developing new agents. And I'm really excited to work with Scotty. He, I think a great measure of somebody who can be successful in this business is someone who's willing to put the work in before they're even licensed, demonstrates an interest in and willingness to move forward with the process, even though it is fraught. And he's done a really good job with that. And so we'll spend time one-on-one over the course of the next 3 months training, working side by side each other so he gets some one-on-one experience. He will also shadow other agents at our firm in open houses and buyer representation meetings and everything in between. And so he'll get a really good rounded experience. I'm not at all worried about these charges that have existed in his past. I believe that they're behind him. And I don't believe that they have an impact on his ability to execute this job well.
Will he be working with a team or individually?
They'll be working individually, but we're a small firm. We're about 24 agents. And so for the first year, he'll really be working with everybody as he sort of gets his feet under him.
Right. Any questions from the commissioners for this principal broker?
I have no questions, but I would say that I don't have a relationship with Mr. Weinberg, but I do know MW Real Estate. It's a reputable firm here in Nashville. And so I think you've picked a good firm, Mr. Chapman, to which to try to begin your career. So best wishes in that regard.
Thank you.
Thank you.
Mr. Diaz.
Mr. Weinberg, I was just curious. I appreciate the robustness of the training program and the team environment that you're set in, but at some point he's going to be cast out on his own to do this work. Is there any kind of check or balances when he first does his first contract to make sure that his transaction file is complete, any advertising, things like that? Just talk a little bit about post-training and when he's an agent on his own.
Absolutely. So we're kind of hyper vigilant about those things. So we work in two processes that really protect our clients and our agents from just sort of negligence, I think is the best way to describe it. And so they will process everything through DocuSign, and all of our forms are in DocuSign, but that's not where it stops. Once they're done with that, it comes into a platform called Paperless Pipeline. And Paperless Pipeline I use to process for signatures, making sure that all the documents are filled out correctly, and nothing is approved, nobody is paid until those documents are accurate and in the correct places. And they do that throughout the transaction. So it's not a dump at the end of the deal. As forms are filled out and signed, they're put through that process. Additionally, and you mentioned the advertising, all advertising that comes out of MW Real Estate has to pass through myself. And so I have to look at all of them and make sure that they're compliant before they are going out the door, either in a sort of a digital format or a physical format in signs and whatnot. And so we've not had, and crossing my fingers because I don't believe that we ever will, have sort of compliance issues related to transactions.
Thank you.
Any other questions from the commissioners from either the applicant or the principal broker? Someone like to make
no.
Excuse me? Did you all have anything else you needed to say? I think not.
I'll make a motion to approve.
Second.
Okay, we have a motion to approve by Ms. Tolbert and a second by Mr. Diaz. All those in favor say aye.
Aye.
All those opposed say no. That motion carries unanimously, Mr. Chapman, and good luck to you. And remember, if you get in trouble, your principal broker gets in trouble, so we don't want that to happen.
Yeah.
So good luck
No,
to
we do
you.
not.
I wish you our best.
Thank you so much.
Thank you all so much.
Thank you. Okay, we're going to move on to the second candidate in the informal appearances. Mr. Brooks and Principal Broker Dwayne Powell. Are they both on the line?
We are. Yes, ma'am.
Okay, great. Were you hearing what we did in the last informal appearance?
Yes, ma'am.
Okay, good. So you kind of know how this goes. So we'll want to hear from Mr. Brooks first. And I said, Mr. Brooks, I don't know if it's
It's Joshua Brooks.
Okay.
Yes.
I just had an initial, so I wasn't sure. So we're going to want to hear from you about what happened, what your circumstances were, and we also are going to want to know what you've done since then to improve your life and why you want to get a real estate license, please. And then we'll go on to your principal broker after we finish the questions for you, Mr. Brooks.
Okay. Yes, ma'am. The circumstances leading up to the things that happened, I got addicted to pain pills in high school. And it's hard to even answer. They were just terrible choices. They were terrible choices that led up to it. I originally got in trouble for the assault. It was there was an ongoing situation, and I saw that person, and I made a terrible decision to confront him. I broke the vehicle window, and that kind of resulted in that charge. Unfortunately, every lesson that I needed to learn at that time was not learned. The pain pill addiction continued, and my life just kept going in a certain direction that was the opposite of healthy. Ended up getting in trouble again. I was at a very bad place in life, and that's absolutely no excuse at all. I made the decision to do it. And it happened. I broke in the store in the middle of the night when it wasn't open, and I know how that looks, and I know how that sounds. But since then, I've been sober off of pain pills for 8 years. I don't drink. I don't do anything. I've cut every person from that time period of my life out, including my own father. I've completed a 4-year apprenticeship in the Sheet Metal Workers Union. I'm a journeyman and journeyman sheet metal worker in the union. I've worked on the Y12 UPF project down in Oak Ridge. I've also remodeled 4 homes, one of which I live in now with my 2 children and my fiance. I've started an online resale business, and I have literally done everything I can to change the narrative of my life and try to provide something for my children that I didn't necessarily have. And then just also be the father for them that I definitely didn't have either. And that's really got a lot to do with why I want my real estate license and why I'm hopeful to get it. I was first kind of got into real estate whenever I bought my first home. It needed a lot of work done. So I would go to work during the day and then get off, and I would work on that house, and I ended up being able to sell it and get a nice check out of it. And did that a few more times. And so that really sparked my interest in real estate. And then I had looked down, and enough time had passed from my convictions that I felt like I had a chance at maybe looking at some other avenues in life that I had a chance at. My mother had gotten her real estate license a few years back down in Knoxville, where I'm from. And so, yeah, I decided to pursue it. Took a couple months off from sheet metal to go to school and make myself as available as possible for this whole process. And it's where I'm at now.
Mr. Brooks, thank you for your candidness and for your honesty. I know this is hard for you to speak about, but I am excited for you to hear how your life has changed and the effort that you've put into changing your life. Do any of the commissioners have questions for Mr. Brooks? Okay, I don't see any questions, Mr. Brooks. So we're gonna talk to your principal broker, Mr. Dwayne Powell. And first of all, one question I should have asked Mr. Brooks: where are you living now, Mr. Brooks?
I live in Johnson City, Tennessee.
So you're out of Knoxville now, then?
Yes.
Okay.
Yes, I've been here the past few years.
In your rearview mirror. Okay.
100%. Yes, ma'am.
Okay. All right. So, Mr. Powell, thank you for being with us today to discuss this candidate. And if you would tell us how you know him and what your plan is for him, what real estate he will be doing specifically, and then a little bit about your training for Mr. Powell, please.
Okay. Well, I mean, we have a career session at Weichert, and he signed up for the career session. It's more like an interview. You know, whenever agents come aboard here, they go through an interview process, and we go through 3 interviews. I also own the real estate school here as well, and Zach signed up with my class, and I got to know him pretty well throughout the class. And you know, he was very forthcoming in the beginning with what had happened in his past. And, you know, he went through the process. He was very attentive in class. You know, my whole thing with my agents is I look at it more so from an educational standpoint. I want my agents trained. You know, we have sales meeting and we have training for like 3 hours afterward on every Tuesday. In my office, you know, we're very structured. You know, I have somewhere around 100 agents. I have managing brokers, and each one of the agents is assigned to one of those brokers for their training, especially head on for the first 90 days. And we do have monthly meetings to discuss how the agents are progressing. You know, I keep a pretty tight rein on all the transactions in my office. You know, it's just like our paperwork. We're very structured. It gets looked at 3 times before they even go to closing. So, like I say, I keep a very tight rein on all the agents in my office. You know, my goal is to put the most professional and the most ethical out there on the street.
Okay, thank you, Mr. Powell. I am wondering, you said that you have managing brokers, and I know you are aware that that's not really a license in the state of Tennessee. Just the principal broker is the one that's responsible.
Right.
So, how many how many managing brokers do you have, and are you still doing the oversight, or tell me how that works in your office?
Well, we call them coaches. Basically, they're assigned to a coach. Each coach, they oversee the paperwork and everything of the agents. You know, again, they've been trained by me. They have years of experience, and you know, when you get down to 100 agents, you know, you need a little bit of help in overseeing what activities that they're doing. And, you know, like I say, I'm very particular on my paperwork, and I want to make sure that the contracts are done, because when the agents come in, you know, they don't know much about the paperwork, and I want every T crossed, every I dotted. They're not really managing brokers; they're coaches. If that makes any sense.
Yes, sir.
But they do. I realize that no, it's not a license, but it kind of helps me keep a rein on everybody in my office.
Okay. All right. Do any of the commissioners have any questions for Mr. Powell?
I would like to abstain from this vote. I'm friends with Dwayne, so
Oh, okay.
I think it'd be better just to abstain.
Okay, so I don't know if that's good for you or bad for you, Mr. Powell. Just kidding. We think a lot of Commissioner Begley. All right, is there a motion?
I'll make a motion.
Second.
Okay, we have a motion by Mr. Gwynn to approve this candidate. Is that your motion?
That's correct.
And a second by Mr. Moffitt to approve this candidate. Any other questions or discussion? All those in favor say aye.
Aye.
All those opposed say no. That motion carries unanimously, except for the one abstention from Mr. Beckley.
Can you
And
clarify his name?
Mr. Brooks' name?
Yes.
Mr. Brooks, what is your name?
What's his
My name's Joshua Zachary Brooks. I'm still mad at my parents for making me go by the middle name. I'm sorry.
Okay, we had down BJ, so we weren't sure exactly what we had. But congratulations, Mr. Brooks, and we're really happy for you, and our best congratulations to you.
Thank you all so much for your time.
Thank you.
Thank you.
Thank you.
Can I ask a question?
Yes.
Yes.
Can we request that these informal?
And I think they were on video and then they turned it off, so we should have just asked for it to be turned back on. But yes.
So we need to stop when we see that and ask them to turn the video back on.
Yes, because they were on video when I first made sure that everybody was present on the line. And so I think just because they didn't go first, they turned it off and then. Yes. Yeah.
Thank you. Yeah.
Good point. Good point, Ms. Smith. Okay, so next we have our waiver request. We have 2 requests this month. The first one is Miss Estella Anderson. Miss Maxwell, what can you tell us about that one?
Okay, we have a waiver request from licensee Estella Anderson. Her license is suspended due to E&O insurance for failing to maintain E&O, and it was suspended at the 131 suspension. And so her request is a waiver of the $400 E&O penalty due to medical reasons, and she has included a letter as well as a medical document confirming the request. Double check where she's at. Based on her penalty,
it shows on this form that we have yes on the E&O.
Yes. So yes, based on and she was not able to get it backdated, which is the reason for the $400 as opposed to $200. Is there was a lapse from 1/1 to 3/30.
She doesn't have her education either, so.
Well, her license does not expire until next year.
Okay, gotcha. And there's no disciplinary history for this person either. So what do you guys think?
I move to waive the penalty.
$400.
Second.
Okay. We have a motion to approve this waiver request by Commissioner Ferris and a second by Commissioner Tolbert. Any discussion on it?
Question.
Yes, sir.
Ms. Maxwell, can we walk through, I know we do this probably every time something like this happens. How did the number get to 400 again? It doesn't start at 400.
Statute.
So it's 200 for 90-day late. How does it?
So you have 30 days once your license is suspended to get insurance with no penalty. And then after that 30 days, if you backdate your policy and there's no lapse in coverage, the penalty is $200. And if there's a lapse in coverage, the penalty is $400 up until 120 days. And then at that point,
120 days from
suspension.
The suspension, which is
January
30
1.
days after it was due. So you're really talking 150, is that right?
Yeah, we're really giving a good amount of time. And then after that, it goes up each month $100 till the first year. And once your license has been suspended for a year, then it moves into revocation.
Okay. Right.
And there is a point, I don't know the exact date. There's a point where you can no longer backdate the coverage. So even the insurance provider will only allow a back date of coverage up until a certain point.
And that's per each insurance company. Some are different on backdating.
So if this was analogous to a utility cutoff, it's effectively 150 days, right? Meaning it's a lot more time to get paid than pretty much any other kind of bill that you have due.
Well, you really only have 30 days with no penalty.
But you have time. $200. You have how much time? 120 days. All right.
Well, yeah, that would be set by the insurance provider,
which is more than the insurance cost. About double.
Okay.
Did that answer your question?
Yes.
Okay.
After this vote, I just want to confirm that the commission would still like to move to open a complaint against the principal broker, or how they would like to treat that.
All right, so we have a motion to approve this waiver, Commissioner Ferris, and a second by Commissioner Tolbert. Any other questions? All right, all those in favor say aye.
Aye.
All those opposed say no.
No.
All right, that motion carries 8-1 with Mr. Gwynn being the no vote. Okay, and so now let's talk about the principal. Oh yes, sorry, 7-1. Kathy's not here. So the principal broker. Do we open a case against the principal broker? I thought the case was automatically opened.
It is. I just wanted to confirm.
So it's open now.
So I can double check. Our typical process is once the case is settled and we've received the insurance with the affiliate or the broker, then we proceed with opening against the PB, just due to the fact that we need to know whether they backdated or didn't backdate, because the same applies to the principal broker.
So is a waiver of the fee considered a dismissal of the complaint? Charge him anything.
Matlock, could you advise us on this?
Sorry.
I mean, I think it could be, but it could also not be, because, well, see, so
such a lawyer answer.
It is very lawyer answer.
You sound like my wife.
So maybe. So the penalty has been waived, but I mean, the underlying issue is that the affiliate did not have their insurance.
And which the principal broker had oversight over that and should have made sure that they had it.
Correct. And so still, like, for example...
Well, let me ask you this. This might help. If this were to happen again, would you report her as having a violation of E&O insurance already? Does it stay on her record?
Like, I mean, so for affiliates, it doesn't show up as a complaint, as anything. It's just, it's one of those things that we actually would call like a fine. And, you know, principal brokers, it's a civil penalty. And so I would still say that the principal broker would still be at fault because the affiliate did not have their E&O insurance at the time. But it's just that the affiliate broker is not paying the amount that they're required to do so. It doesn't absolve the issue that
you were severed,
that they didn't have insurance, because they still did not have insurance.
And as a principal broker, I require that my agents provide that to me by January 1. Mm-hmm. And I know who hasn't and who doesn't. It wouldn't take me 5 months to get rid of that person, knowing that they were getting me in trouble as the principal broker. So
you can make the argument either way about whether the individual pays or not. But I will say that sometimes we do have, when transactions that have been opened, because an affiliate maybe states that they're going to do something and they don't necessarily pay, but the principal broker is still on the hook because the underlying action of what got them there still exists. So that's my take. Does that give you clarification of my
when did this person ask for the waiver? What was it, last month they asked for it?
So it looks like, I don't know the exact date that this initiated. The E&O did, was obtained on 3/30, and it looks like it was added to their account on 4/3. And at that point, our staff sends out what is considered like that fine letter. And so I don't know if it's just that they came back to us and said, we don't want to pay that, and realized that their license was not going to be moved. We don't move the license out of suspension until all requirements are met, which would be getting the insurance and paying the penalty. And so it could be that they reached out to us because it looks like we send a letter that states the penalty and how to remit the payment, and that was sent on 4/3 as well. So I don't know if it's that the licensee then realized their license was not going to come out of suspension and reached out about the penalty. We didn't get this request letter until June 8th.
Mr. Gwynn?
So from, maybe this is to Anna, from a insurance company perspective, all right, after, let's say, the 30 days, they don't have insurance, right? Or they're in, when this penalty phase is going on, so they close a transaction with no E&O, let's call it, but they've held themselves out to the public as an agent with a license, presumably with insurance. So that, does the insurance company say, we're not going to, if so, there's an issue, all right, and there's a claim, what does the insurance company do?
There are two issues. I can't speak necessarily for the insurance company, but I would probably think the insurance company would not pay. But the second issue is that their license with us is suspended during this time. So they're practicing unlicensed.
So they're practicing unlicensed. Now the principal broker is also has a problem, correct? Because this agent works for the principal broker, and it's his or her job to make sure that somebody out selling real estate has insurance, correct?
Correct.
Okay. So
Required by the state of
correct.
Tennessee to have a license
So in
and
this
insurance.
That's what it causes. To me, it seems like that it's the importance of having this E&O insurance. So what happens when somebody transacts real estate without paying their insurance in case of this? I mean, it doesn't say that she did anything during this, let's call it 120 days or whatever it is. So how does that work? That's what I'm trying to understand from.
So if they're I mean, there's no way for us to know about their specific transactions unless, that person was to, one, tell on themselves, which happens more often than not, you would not believe, or two, we were to find out about it, then we would open up a complaint for unlicensed activity, right?
Could it fall back to the broker?
I mean,
the broker's insurance?
The brokers, I don't know if it would fall back to the broker's
No,
insurance.
because they're an independent agent.
Right. And unless there's I don't know how the insurance is necessarily falls under that. But I mean, it could be an issue for the broker, failure to supervise. So it depends on what this commission would decide when that complaint comes before us.
would also put the state of Tennessee and this real estate commission in a little bit of peril, because if there was something that happened during that time period, they could come for this board for to get recovery of any damages brought to them. It's why we have the law. I mean, yeah.
Yeah, that's why we have this is all true and all accurate. My motion was based on what did happen, what is on the books, which is just the waiver of the penalty. But
Voted on this.
Yeah, we already
Right.
voted on it. Now
Right.
we're talking about the principal broker.
So-
We open a case against the principal broker.
and to that, I'm in the affirmative that we do, and make sure that this individual gets insured and gets their license out of suspension.
I feel like the principal broker let them down, number one. I mean, they should have immediately said, go take care of this, or they could have worked it out amongst themselves or something. So is that a motion that you're making, Mr. Ferris?
Well, I don't think we need one. I think there's a complaint already open.
Okay. Well, is there a complaint already open? Hey, that was like,
Yeah, sorry. I'm looking right now.
Not the first time this is.
yeah.
I mean, typically, normal process is we open a complaint against the principal broker.
Right? I mean, it's that January.
That's why I'm
bond.
not sure why we're even talking about it, really.
Well, typically it's in coordination with their penalty getting paid, and there's a transaction that we do. So we have sort of this process in place where, like, our staff opens it's called an 8090. That's so that the licensee can pay the penalty. And then from there, that approver then goes to our complaints division to open the complaint against the PB. So if it's not open, then that's likely why, because this one has not been closed.
I don't know what's unlike, why this one is any different than any of the thousands that we've done before.
We're not going to collect the fines at the first part of this.
And in the past, they've always opened them simultaneously.
I'm saying typically that 8090, the approver then opens with the 8090 transaction. But we can certainly, it's not like we can't just go ahead and open it. Okay, there is.
So the question is there one open?
Yes, there's one open.
Okay, that's all we need to know. Okay, y'all ready to move on to the next one?
Yes.
Okay, the next one is Stephanie Daniels. If would you tell us a little about that one?
Yes,
Ms.
this
Maxwell?
one is a medical waiver request for the license penalty. So this licensee expired 5/7/2023 and had accumulated a $100 penalty. And so they are currently in an expired status. They still appear at the time this was written, I'll double check it to make sure we're current, needed to do their education. But they're requesting a waiver from the $100 penalty and have included a doctor's note.
And I took note that this was from a dermatologist. Oh, anybody have any thoughts on this one? They're asking for a $100 fee waiver.
Make a motion.
And we have a motion by Ms. Tolbert and a second by Mr. Diaz to approve this request of a waiver. Any discussion? All those in favor say aye.
Aye.
Any opposed?
No.
Okay, that motion carries 7-1 with Mr. Quinn saying no. All right, next we're on to our education director's report.
Yes. Sorry. I was trying to look this up. This licensee still has not done the education. So I just want to note that the penalty will continue to go up until all requirements are met.
We waive the current penalty but we could see this again if the license.
See, I don't like that a bit. I don't like that a bit.
What are our choices here?
We could.
They have to get their education before they can be renewed.
Okay. This was not included. She would like to retire her license.
Oh,
So the way that would work is at the time that she wanted to activate it, she would have to do 16 hours.
If she wanted to bring it out of retirement.
Okay.
all right. So, okay. All right. So we're going to move on to E. Ross White, our education director.
Good morning, Madam Chair, members of the commission. Nice to see you this morning.
Good to see you.
I have before you today the June 14th education agenda. I have reviewed all the new providers, their courses, and the instructors for today. Bring them for your review and approval is satisfactory.
Did anyone have any questions for Mr. White about any of these courses? We're going to take a vote on the courses first.
J1 through J42.
Make a motion to approve these courses, J1 through J42.
Proper motion by Mr. Diaz and a second by Ms. Smith. Any discussion, questions? All those in favor say aye.
Aye.
All those opposed say no. That motion carries unanimously. And now on to the new providers, please, Mr. White.
Thank you, Madam Chair and members of the commission. Before you today are 4 new instructors for your review on your iPads there.
Anyone have any questions about any of these new instructors?
Can I hire that second one as a bodyguard?
Can.
I'll make a motion to approve these instructors.
Second.
Right, so we have let's see, we have a motion by Mr. Beckley and a second by Mr. Diaz to approve these instructors, these 4 instructors. Any questions or anything we need to discuss? Okay, all those in favor say aye.
Aye.
All those opposed say no. That motion carries unanimously.
Thank you, Madam Chair.
Thank you. We appreciate everything you do, Ross. It's sure been a joy to work with you.
Madam Chair, I'm honored to have worked with you for these years and look forward to a lasting friendship.
Absolutely. Thank you. Okay, now, Executive Director report.
Yes, I have a couple updates for the commission, just really housekeeping items. There's no July meeting, so you're off for July. Woo! And then in August, the commission will be in a different location. As you might be aware, we have some technical difficulties in this room that we are working to improve. And so the first step of that process is some small construction on the room. You still will not get new technology yet, but the construction will be first, and then they will be updating the technology at a later date. And so the room is closed for the end of July through the middle of August. So it falls kind of right in our meeting. And so we have worked to use one of the rooms at this new library back here. So it should be nice and it will be close. So
where's the library?
It's the State Archives Library that was just built like right
Oh,
back
not in this
here.
building?
Not in this building, no. Yes.
Do you have the address?
We will make sure to get everybody the address and the room information and the parking and all of those details. But it's brand new, and so it should be nice, and it should be able to accommodate if we were to have a large group. and it's not far from here. And it also has the streaming and the technology capabilities that we have come to need.
I have a question. When
Yes.
this room is renovated,
Yes.
will the format?
I have not seen plans, and so to be honest, I'm kind of confused, like what construction they're even doing. So I'm not necessarily the right person to ask. I just do know that it will be shut down for close to a month. And so,
It'd just be a matter of remodeling and painting and carpet and that kind of thing too.
yes, I think, they're looking to just do a refresh and then update the technology to make it easier to have interactive meetings in the future.
I wish there was some way. It's very difficult, especially for these guys over here, to see that screen. And otherwise, I mean, I see people also having to flip around. So
Yeah, we can see that.
oh, you see that one? See, I'm looking at that one. Okay, sorry. So you do see, all right.
Yes, I would hope that would be part of it. I communicated how great Jackson's room was, how they have the TVs, and
Nice room.
very nice. So
will parking for the August meeting be at that building, you think?
So
Or
when
is it gonna be
we
remote?
booked the room, they do have a parking garage. It's on a first come, first serve basis. Aaron's just coming over to tell me yes. So yes. And then my last item is not definite, but the Arillo annual meeting is in Montreal, Canada, and it's September 18th through the 22nd. And I've had conversations. This is a special request because it is outside of the continental U.S. And so I would like to submit a request if there's anybody that would want to go. It's not guaranteed, but I just wanted to check if any commission member had interest in attending, and if they did, then I would like to go ahead and submit a request on their behalf. So just wanted to bring that up for discussion.
What are the dates?
It's September 18th through 22nd. Yeah. Okay. Yes. Yep. Okay. We have some special guests.
Yeah, hey, thank you all for letting us interrupt. I think the commissioner wanted to come down and share a few words.
There we go. Thanks for letting me interrupt. So I know some of y'all a lot better than I know others. My name's Carter Lawrence. I'm the commissioner at Commerce and Insurance. Back in 2017, I joined Commerce and Insurance as the assistant commissioner for the regulatory boards. And it was fairly shortly thereafter where I had the privilege of working with Trek to hire a new executive director, your very own and soon to be departed Caitlin Maxwell. We went through the process of working with a selection committee and interviewing a bunch of candidates. And I think you'll all agree that we had a really great selection, and who ended up being a really great leader for y'all over the last 5 years in Caitlin. Yeah. And as much as y'all are going to miss her, we're going to miss her as well. And Caitlin, we certainly wish you the best. But 5 years ago, there was another meeting that I had. Marcia, I went down off of the new McEwen exit, met you for lunch when your first term was wrapping up, and we met. Myself and the then Deputy Commissioner Brian McCormack met with you to talk about whether you would have interest in serving for another term, and we're really glad that you did. And I think that the commission and the profession and ultimately the whole state have been better by you agreeing to serve for another 5 years, and really appreciate you stepping up to serve.
Thank you so much.
So it's interesting the path that the assistant commissioner for the regulatory boards has had over the last the kind of the recent pathway. Brian McCormack was my predecessor, who I think of this group, Marcia, you're the only one who would still know who Brian McCormack was. And Brian went up to deputy, and I followed from Brian in Brian's steps. from assistant commissioner to deputy, which is the same as what Toby's done. And so most of y'all know Toby, who was the assistant commissioner after me, and certainly everyone now knows Alex, who is ably leading the division. But we've been really fortunate in dealing with one of our biggest, one of our most important, and one of our favorite boards and commissions here with TREC. That we've had great leadership, we've had great cooperation with y'all, and I just want to take the opportunity to come down and say thank you, and that we really appreciate Marcia, Caitlin, we appreciate your service to the state of Tennessee over these last 5 years, and let you know that we're really going to miss y'all. So thank you so much. Really appreciate it. And I guess with that, Toby, Alex, anything?
Thank you so much.
I want to say thank you to you too. And I remember he would come to a lot of our meetings, or he would pop his head in, and he was taking over for Brian, who had done the same thing. And it's been a joy to see you move up to the position that you're in now, and that we're really happy and excited about that too, and know that the state of Tennessee and Commerce and Insurance especially is in great hands with you.
Thank you.
I just want to echo what the commissioner said. We're very fortunate to have a good commissioner, and we were just at a new employee meet and greet where we're trying to build culture within the department, and it's astounding to see kind of what Commissioner Lawrence has kind of done for us. I'm kind of sucking up right now. IPP time is upon us, right? So, Marcia, thank you for your service. It's been great to know you, and so many of you. Good to see you and work with you guys. Caitlin, think the world of you. Congratulations. Good people go to do good things. So, I know we'll keep in touch. And to all the staff, thank you all for everything you do. I don't think you'll get enough praise because this program is a high volume, consistently well done program, and the board should know that from the administrative standpoint. So thank you guys for everything.
We appreciate you all coming down too. I know you're very busy.
Yes, ma'am. I just wanted to thank the commissioner and Toby for popping down. I'll reserve my comments, and we'll get to the business that's before us a little later in the meeting. But just want to thank them both for coming down. Yep. Thank you.
Appreciate it. All right. Thanks, y'all.
Thank you very much.
All right.
Okay, Ms. Maxwell, did you have anything else from your executive director report?
Just to finish up the discussion, I can't guarantee anything, but I would like to submit it just as a request if there's interest in anybody from the commission in attending.
Gorello meeting in September.
Yes, and the dates again are September 18th through the 22nd.
And as I roll off of this commission, I also roll off of Arello. So I would like to just put in a plug for Arello that we keep that alive in this commission. I do think it's very helpful, continually getting questions from people from all over the United States and things that have not happened in Tennessee yet. So it lets us know to be on the lookout for things, and then also how people are handling problems in their state. That's the same things that we have. But I'm very proud of Tennessee because we've done some great things at Arello too, and I hope that one of you will take up the baton and carry that.
Yes, we've been so lucky to have a commission member who has served as president of Arello, which is really a big deal. I think the first in Tennessee. And so Marcia has really made a name for Tennessee and left a mark. And so I definitely think there's a lot of benefit in that. And I know our staff would like to attend. So at the very least, the request will be for the education director and the attorney. But if anybody else would have interest, we can submit and request.
Commissioners?
It's typically, yes, no more than 5. And so we have in the past had times where we've been able to send 3 staff members and 2 commission members. But
I will say this also. Arello was in Vancouver some years back, and at that time, we were not allowed to go outside, travel outside the 48 states. Now that was under another governor. I don't know what the plan is now for it, but I went to Vancouver myself because I was on a committee and had a leadership position. But There is a chance that the state might not pay for it, but it is Montreal, so great place to go.
And September shouldn't be too cold.
September will be perfect.
So, if you have interest, contact me soon.
Okay. Anything else, Ms.
Nope.
Maxwell? Do we want to take a break and then come back, or we want to go ahead and have them come forward and let's talk about the executive director position? Yeah, we're at a good point.
Great. Well, hey, thank you all for letting us pop in again. I know the commissioner was a bit tight on time, but it was important to him to come down and to Marcia to acknowledge your service and Caitlin's as well. So just want to say thank you to both of y'all. You'll certainly be missed. It feels like a little bit of a new era for all the work that the TREC Commission has done. So we'll get through it together. So I just wanted to come down and kind of talk through the process that we foresee playing out for the executive director search. This board obviously has the statutory authority to appoint an executive director. We have a couple other boards inside the division that have very similar authority, and actually just got through with a very similar process using the same playbook. I think was successful, and that board and the department were very satisfied with. Actually, we just selected a new executive director for the contractors board at the beginning of the year here. And so what I'm going to propose and outline today is a very similar process. So the chairman was kind enough to approve the unfreeze, which is the first formal step, just indicating that we do intend to fill this position. I'm also currently working with HR on the job description. And so our intention would be that we post that job description on the state's hiring portal, just like we would any other position. And additionally, we would share that job posting with all of you. If you've got folks in your network that you wanted to share that with, we really, I think, would benefit from casting a wide net. And not that Caitlin is replaceable, but we'll certainly take our best shot to find the best possible candidate. And I think casting a wide net probably sets us up for success there. And so the other piece that's critical to this that I wanted to mention is I do think that this role is likely to be competitive, and that we'll see a good applicant pool. And so obviously having the board involved in that process is a very critical component there. And so what the contractors board opted to do, and then other boards have done as well, was for the board amongst themselves to choose a liaison to participate in that interview process with myself. And so we would do at least 2 rounds of interviews, myself and HR kind of taking the first big swing at a large round of interviews, and then that second round, the board liaison and myself interviewing a set of finalists in person. With that point of the process completed, my goal, with the commission's blessing, of course, would be to put a recommendation in front of you all at your August 9th meeting. And so I would just say that my goals are to find the best possible person to serve you all, but also someone who's got the governor and the commissioner's priorities in mind, and is going to serve well. So happy to answer any questions or anything we didn't cover.
Oh, I did want to say this. So we're going to be looking for one person on this commission to help with this. In the past, I actually, in my 10 years, have been with 3 different executive directors, and it is such an important position. In the past, John Grease was on 2 of those. He was chairman at the time. I will not be here as I'm rolling off after tomorrow. But there was some time constraints on us now because we're trying to get this position filled as quickly as possible. And I can tell you, you want to get it filled as quickly as possible, because we have had times when it didn't fill as quickly as we needed it to. And not only for us, but especially for our staff. they need that leader in place. And so we're going to need one person from the commission to work with Alex on making the final determination of a person that they will then bring back to the commission for the commission to vote on. I will say this, DJ, you and I are the closest ones to this office, and I haven't talked to you about it in advance, but if this is something that you might be interested in, I think it's a whole lot easier maybe for you than for someone to drive from Kingsport or Memphis.
Yeah, by all means, I'm glad to help out at this time to
That'd
be
be
that
great.
liaison. Yeah, no problem.
That would be great. Is everybody on the commission okay with DJ being our representative?
Absolutely.
I think if the commission would just entertain a formal motion to designate Commissioner Ferris and then to have that vote on the record.
I'll make a motion.
All right, we have a proper motion by Ms. Smith and a second by Mr. Moffitt that DJ be our liaison from the commission. Any discussion? All those in favor say aye.
Aye.
Any opposed? That motion carries unanimously, DJ, and thank you so much because I know you're the perfect person to help Alex with this.
Well, thank you for your confidence. Alex is going to carry all the water.
Yes, sir. I'll do the heavy lifting, and we'll work around your schedule.
And I'll go on the record too that we're going to greatly miss Caitlin, and as the commissioner said, or as Toby said, good people go on to good things. So best wishes, Caitlin.
Thank you.
I spoke with Alex this morning and I told him, I said, well, we just need someone exactly like Caitlin. That's what we need. When you find that person, that's the person. So
yes, if we could put that in the job description, we
okay.
So
Yeah,
I want to make a couple other things just clear to the commission for transparency's sake. So obviously, Commissioner Ferris will be riding shotgun in those interviews, but I do want to be clear that I'll be providing timely updates to the commission as well. So as we receive feedback about the posting, I'll be in touch with y'all directly. Again, very similar process to what we did with contractors to kind of share with y'all, hey, here's how many applicants we had. We want to make sure we're casting that statewide net. And then the additional point about this role that I would mention is statutorily, the individual in the executive director role is required to pass the broker's exam. I went ahead and checked with legal and HR beforehand just to make sure we were clear on that. So that could be an individual who's already passed the exam, but there's also plenty of leeway there for the commission to entertain someone who doesn't have that background and could pass the exam after being appointed. So I just want to be clear that we have a lot of leeway to cast a wide net and get the best possible candidate.
I think that's what we did with Caitlin. She didn't have a broker license beforehand, but as soon as she hired, Caitlin, she passed it just like that, which is a huge feat in itself. So it sounds like the system is good. Our HR department's fabulous here. Alex leading it and DJ helping. I think we're going to be in good shape. And so hopefully, and everybody really pray hard about this, that we have somebody at the August meeting. It's timely that we're not having a July meeting. So there'll be some new and exciting things happening, hopefully, in August. If not, then it's Alex's responsibility to keep us going as a regulatory board. I know that Anna Matlock helped a whole lot the last time also on that. So.
Just the last point I would make, and then if there are any questions for me, happy to answer those, and don't want to take up any more of y'all's time. So I will be standing in the gap for the next couple months. So Rihanna and the board staff will be reporting directly to me, and I'll be checking in with them on a very regular basis. So again, Caitlin will be missed, but to the best of my ability, we'll run things smoothly. And we'll continue to provide y'all updates just like we always have. And then, Caitlin, I'm not sure if this was mentioned earlier, but also want to thank DJ. Again, your proximity has volunteered you. So DJ will be assisting us with the board's sunset hearing in July. So I'll be involved in that process as well.
Right.
Any other questions for me? I really appreciate y'all.
So we as commissioners get calls from everywhere. Who do I talk to about things? it's either been Caitlin or Anna. So what do you suggest at this point?
Anything that would typically be directed to Caitlin should come to me.
I will just say what is really nice is when you send an email and say, so and so has contacted me about X, and then allow Alex to kind of, if it's something that truly needs to be him, because that's a lot better than somebody just randomly out of the blue.
Mm-hmm. Yeah.
So
you do the communicating. Don't tell someone to communicate with Alex. Is
exactly
what she's saying.
And I'll do the best of my ability. You know, if it's a licensing question, getting that to the proper staff. If it's legal, if it's complaint related, kind of parsing that out, and then those things that I need to respond to or get involved in directly, I'm happy to do that.
And don't copy all of the commissioners just in case it's something that has to be voted on, so we don't break those rules.
And I think most of y'all have my cell phone, so you know how to reach me if there's any concerns. And again, I really appreciate y'all, and we'll be very involved in this, and hope that we get an excellent person in front of you in August.
We appreciate you, and good luck to you also.
Hey, thank you. Thank y'all.
Thanks, Alex.
Thank you, Alex.
Okay, Ms. Maxwell, was there anything else on the executive director's report that you have?
Nope, that was it.
Okay, so why don't we take a 10-minute break before we start the legal report, and then we'll jump right into that right after the 10 minutes. It is 9:46 right now.
It's the oh no you didn't face.
We're not actually taking that.
I do love that this group knows what the rules are, and I've not seen in my time as chairman anybody breaking those rules, so that's good. All right. All right, so I'm going to read you the list of cases that have been pulled from the consent agenda. At this time, does anybody else have any that they want to add to the list? Okay. So here we go. If you want to write this down or not, these are the ones that have been pulled. Number 6, 8, 12, 15, 16, 17, 18, and on number 18 through 24, I think it's 25, isn't it? It's 18 through 25. That's all one case together. So, and that was one that I had pulled, and I wanted us to talk about all of those at the same time. So 18, 19, 20, 21, 22, 23, 24, and 25. And then we have number 39, number 48, number 57, number 64, number 69, number 73, number 74, and number 76. Some of these were discussed that were already on there for us to discuss. So if you're ready, would someone like to make a motion?
Motion to approve and accept council's recommendation for the consent agenda, except those cases that were called out by the chair.
All right. Ms. Tolbert already seconded it. So we have a motion by Mr. Diaz and second by Ms. Tolbert. So all those in favor of the motion say aye.
Aye.
All those opposed say no. Motion carries unanimously. So let's all get our iPads up going.
Repeat who made the motion.
The motion was made by Mr. Diaz and second by Ms. Tolbert. All right, so the first one is number 6. Okay, this one was about offering education in a real estate firm. And this was under, let's see, this is one of Miss Matlock's cases. And I agree with her about a $500 civil penalty. I pulled this one just mainly because I wanted to say it out loud, because I have had several people calling me about real estate firms offering education in their offices, and you cannot do that. The statute says you cannot do that. I just wanted to make everybody aware, anybody that's listening to this, that you cannot do that. In other words, I would like to accept the council's recommendation if somebody would make that motion,
So
please.
moved.
Okay, so we have a motion by Mr. Diaz. Is there a second? Second by Ms. Smith. Any discussion? All those in favor say aye.
Aye.
All those opposed, no. That motion carries unanimously. The second one is number 8. Ms. Smith and I both pulled that one. Ms. Smith, you want to start?
This one was talking about the recovery fund, and it appears that they were asking about the recovery fund being used for commissions. And
Yes, so I can, I had this one up for discussion. I just wanted to give a brief kind of overview of what was going on. So I provided everyone the statutory citation of what is required to make a claim for the education recovery account. So what we have, the complainant is a real estate broker, and the respondent is a principal broker. And so they have a judgment that they have received from a court, and I believe it was for an amount over $17,000. It's related to outstanding commissions that they are due from the respondent, and the court found that they were in favor for it. And so the complainant stated that they are making a claim to the real estate education and recovery account for the amount from the judgment. And so, as we know, in order to make a claim from the account, you do have to have an outstanding judgment. However, the issue is that if you look at, it's right, I guess, on the second part of it, 6213-208D3 states that a broker, affiliate broker, or timeshare salesperson acting as an agent in a real estate transaction shall have no claim against the account. And so one of the conversations that I wanted to have with the commission is to see whether you believe that if this would fall into this particular category. I kind of view a real estate agent receiving a commission acting as an agent in a real estate transaction to receive a commission. And so I think that means they're barred from recovering from the real estate education and recovery account. But otherwise, I just wanted to see what your idea or what your kind of thoughts were on the matter.
Seems that way to me.
It's pretty black and white to me.
So is there in the record a confirmation of agency as part of this transaction where the complainant in this narrative was an agent in the transaction?
Right. So they were the agents in the transaction. These are commissions due to them from the principal broker that were never paid. The judge found in their favor that this amount was due to them. But I don't think that they have a claim on the account as they were acting as an agent in these transactions.
I agree with that. And also, I was wondering, since this was in civil court, were they already awarded the money? I mean, the judge said they're due the money. So I'm not sure why they would be trying to double dip and collect here also.
Well, that real estate education recovery account still... It doesn't bar an individual from making a claim. It's when you're aggrieved from another real estate agent in any kind of circumstance. If we look at the other claim from another individual, they were owed a certain amount of money from the court judgment as well. And so when you're owed a judgment, that means that individual is required to pay you. So that whenever we get a claim, that individual is going to have already received some form of compensation coming to us from the claim. So I guess my understanding is this individual does not believe, since they have had to go to court to receive this amount because they haven't paid them, they don't think they're going to get it. And so this was the avenue that they were going to try and reclaim that amount.
But basically, what the code says, then they really don't have a claim.
Right. I think because they were a real estate agent acting in a transaction, that they're barred and they're not able to make a claim to the account.
And this was a principal broker didn't pay someone who left their company. That's what this one is. So you know, it looks to me like it's pretty clear that they're not allowed to do it with that statute that you've
You get a
presented
decision
us.
from us?
You have
Right.
to have a
Yes,
vote.
I wanted to make a decision. I just wanted to make sure that we were all on the same page. And since it was a claim that they were making, I believe that it deserved some kind of discussion from the commission.
Move that we deny this claim based on statute 6213208D, Part 3.
All right.
So we'll dismiss the complaint.
We have a motion to dismiss from Mr. Diaz and a second by Mr. Ferris. All those in favor say aye.
Aye.
All those opposed, motion carries unanimously. Number 12. Number 12. So my question was, this is the one that the realtor did not disclose that there was an HOA. And the recommendation is for a letter of warning. I just thought maybe a letter of warning might not be enough on this one. This person has already bought into this development, and then they find out there's an HOA. And I think it, as it reads, that they probably found out at the closing table.
The individual already knew prior to closing that there was an HOA. So that's the reason that I recommended a letter of warning, is because my understanding is that the homeowner had a conversation with some of the other individuals that lived in the area and knew that there was a homeowners association. And so they were aware that there was one. However, the real estate agent at the time stated that there was not one. So there was knowledge of the homeowners association.
It's just bad that the realtor presented it, the licensee presented it, that it was.
Was the respondent the complainant's representative or the seller's representative? Do we know?
Sure, they're the client's representative.
It says according to MLS listings. So the respondent was dependent upon the MLS information.
Well, there is a property disclosure report that was marked no HOA. And if I get that from the seller, then I'm assuming they're fraudulent in filling that out if they know it, or there's no HOA. So I don't feel like the agent. I mean, I think a letter of warning's enough for that reason, because there's a property disclosure form and it should be stated on there.
Hey, would you like to make that motion, Mr. Bagley?
I'll make a motion to accept the letter of warning.
Second.
Hey, we have a motion by Mr. Bagley and a second by Ms. Tolbert that we accept council's recommendation of a letter of warning. Any other discussion? All those in favor say aye.
Aye.
Any opposed say no. That motion carries unanimously. Number 15. Okay, so on this one, I was wondering, to begin with, the respondent did not respond, and so there was $1,000.
Right. So initially I thought they did not respond, but I found the response.
Okay.
So that is the amendment to it. So the amendment to the amount is that one initially thought that they did not respond, but they made it, their response was to two separate citations. So they had a citation, one in their individual name and then two to the firm. So they had submit a response. And then the second one is that you'll see that I had submitted a $500 civil penalty for violation of 1260-02-.22A and 2B.
And what is that?
Those, it states that the rule provides the firm name is either the firm name or the DBA. And so I can't find them in violation for both if it states that there's an or. And so I made an amendment to just two. So the new civil penalty amount would be a reduction from that to $1,500, removing the $1,000 civil penalty for failure to respond and one of the $500 civil penalties.
Motion to accept council's recommendation.
Second.
Question. Could you have gone to 1,000 for the second, the 500? That could have gone to 1,000, right?
It could have.
So it could have really been 3 to 2, 3,000 to 2,000. Okay.
Okay, so let me back up. There was a motion by who? Mr. Diaz, and a second by who? DJ. All right, so we have a motion by Mr. Diaz and a second by Mr. Ferris that we accept council's recommendation of a $1,500 civil penalty. Any other discussion? All those in favor say aye.
Aye.
Any opposed say no. That motion carries unanimously. Number 16, Ms. Smith.
That was a discuss, and it was where bought the house.
There was no disclosure.
There was no disclosure, and then you got new information.
Correct. Attorney for the respondent submitted an additional response to the amount, and so essentially they stated they did not initially submit confirmation of status form, which they provided.
They did provide that.
Yes, they provided the confirmation of agency status form, which they stated was inadvertently left out of their first response. And then that's basically the argument in their first paragraph. And then the second paragraph is more so a response to 6213 for 7A, which is the violation I had written for not providing, not engaging in self-dealing on behalf of them and themselves. So not providing the written disclosure information that they were personal interest form. And so essentially they had provided more information as to why they believe that should not.
They did not provide a personal interest disclosure.
They did not provide a personal interest disclosure.
What is your opinion?
To discuss it.
To discuss it.
Well, I noticed that you also say reassess the $1,000 sale.
So nope, mine says the dissemination. I said I just provided the information. So the confirmation of agency status form is definitely helpful in providing
Now, but you had to get it after you asked for it.
right, asking for that. Of course, all of this information would have been helpful as providing in the beginning. We always love for people to do that in the beginning. It's still concerning to me that the personal interest disclosure information was not provided in writing, but the Respondents Council is very adamant that this information was known to the parties.
Can he prove it? Can he prove it?
Looks like there's a text message. Does a text message count as proof?
Can't wait to get out of here and you
So
have
that
your
you
home.
can have your house.
Right, so that's what they're saying, that's the proof of
So-
them knowing.
So back up again.
But knowing what?
So you have no personal interest disclosure form.
No, I do not.
Required by the state of Tennessee.
I do not have the form. And so they're saying in lieu of the form, they
want us to construct notice.
Yeah, there's
out of
no
what they're
in
sending us.
lieu of.
Is that what?
Yes.
So do we want to construct notice outside of a personal interest disclosure form? That's what we're being asked.
And so the original recommendation was a $2,000 civil penalty. So if we let go of the $1,000 penalty for what was it that they did do? The personal interest is what they don't have.
They don't have it.
Yeah, they just have the disclosure form.
So
it looks like it needs to be reduced $1,000. They're still guilty of not having the personal interest form.
Do you have the confirmation of agency status on file for us to review?
I do have that.
Would it be prudent for one of us to take a look at that? And I'm glad to look at it. And I mean,
But if she has it, she has it.
well, no, but I guess I'm wondering if it has the buyer's name on there.
But she just said she didn't have it.
No, I have the confirmation of agency form. I just don't have the personal interest disclosure.
I know, but on the
Different forms.
I know on the confirmation of agency status, who's the buyer? Well, how is the buyer listed?
Little. I have a little problem with this, just as our fiduciary responsibility that a client, and there's a $250,000 spread in 30 days. Seems like you probably could have met somewhere in the middle and got rid of that in a fire sale or something and still help the client. But this is just against the affiliate broker, not the broker yet, right? Or the owner, or whoever the buyer was.
This
The
complaint.
company bought it, right? It's just the one. Yeah.
Herder.
Clinton is an out-of-state resident.
Yeah, but the
Yes, this
buyer was the
complaint is
firm.
against the affiliate broker. So for the confirmation of agency status, the seller is listed as the complainant. The buyer is listed as the entity, and under that, the licensee is listed as the respondent.
They representing both sides? Were they a facilitator? Or
So it says the seller is unrepresented, and it says that for the buyer, the respondent is the agent for the buyer.
designated agent?
It's the checked agent for buyer.
Buyer.
Hmm?
The entity is listed as the buyer.
Still doesn't.
Is it clear that the agent and the entity? Is it clear that the agent has the personal interest because the name of the entity is discernible, like Jeff
Name
Diaz
of-
Properties or
no,
something?
No.
Okay.
Because that was part of their claim too.
So like
Essentially the same.
I mean, the firm name, the firm name is very similar to the company name, but not like the licensee name.
Licensees.
So,
Go ahead,
like,
broker.
for example, the firm would be called like Marsha Frank's Realty, and the company's name is Marsha Frank's Corporation. But it's not like a person's name, it's like something else similar.
And there's an affiliate agent.
And there's
Agent
an,
for the tracks.
and yeah, and then there's the respondent's name.
And so part of the problem was that it was an unrepresented seller that didn't know at the time to ask for a personal disclosure, personal interest disclosure, but it's still the agent's responsibility to provide it.
Right. And
So their attorney's arguing constructive notice is basically what they're doing. They're saying they knew, even though the form's not filled out.
But it's not constructive notice. Is not the statute. It's the form. Is the statute.
And if to go back to the first offer that got canceled because of financing, supposedly, the respondent probably was representing the seller at that point, and there should have been a change of agency status form in between because.
So the first transaction, a separate agent was representing the buyers. And so this second respondent intervened in the second transaction.
What I'm saying is, the first transaction, the respondent on here that's representing the buyer was probably in the first transaction representing the seller, and there was a buyer's agent. Then somewhere when they crossed, there's a thing that says a change of agency status form saying I'm no longer representing you. You're now on your own. And here's a new form that says I'm representing this buyer, which is also the guy I work for, the owner of my company. So then I'm just saying there's one more form there kind of missing. Agency status.
Almost, but so the first transaction, the seller was represented by someone else in the firm, and they were supposed to sell to some other third party, and financing fell through. And then this respondent who owns the firm came into the transaction and said, I'll buy the property. And so he then entered the situation and became the new buyer under their company name and represented them as their buyer's agent. So the respondent in this instance was not involved in the first transaction. They saw themselves as essentially saving the transaction by offering to purchase it after financing fell through.
Okay, and so the complainant's initial listing agent with that firm, after the first deal fell apart, they terminated their listing agreement.
Right. So we had originally a complaint against them, and so. And that narrative is in there, and they stated that they believed that our respondent right now essentially took advantage of the complainant in this situation.
So that's a affiliate claiming that against a principal broker and owner of, right?
The way this is written, the respondent is the original the whole time. It's the same agent, but the respondent's owner is the buyer that came in and saved the day.
Not the respondent.
Not the respondent. The respondent, it says, was involved in the first deal and then worked out the second deal, and then the respondent's owner of the firm came in and saved the deal. Is the way that first paragraph reads, but I'm not sure. Like, I think the respondent was involved in both transactions, but I don't know. What do you think? I mean, we just need to vote on it, but I mean, it sounds like to me.
Like, but bottom line is, I don't have a signed personal interest form.
That's all we know for sure.
I know that for sure. They admit that that form does not exist. So that form does not exist. The argument from Respondents Council is that they were aware that Respondent owned the company, and so maybe they didn't need the form. So they're saying essentially, kind of like the HOA situation, they had knowledge,
but it wasn't to their discretion to have.
We just don't have the form.
Right.
Yeah, so, go ahead.
Forms required.
Originally, what's the complainant complaining about? That they sold the house too cheap?
Yes, the complainant is upset because they sold the house to the respondent for an amount, and then the respondent sold it and got a whole bunch, sold it for a much higher amount.
And the reason they sold it, the closing happened. I don't understand the problem. I mean, other than the fact, they closed the house at a price.
They didn't have the personal interest.
Okay, so they're saying
it's
because
required in residential.
So are they saying that they would not have closed had they seen the form?
So no, essentially no. They don't know about the form. The form is us talking about the form. The complainant's main issue is that they feel like taken advantage of by the respondent because they sold their house for, let's say, $200,000, and then the respondent turned around and sold the house to another party for $500,000.
Which that makes no difference to us.
Right.
I mean, that's just called the market.
Right. So that's not something we could ever do in a complaint. So that's like the underlying issue.
Well,
in a short period of time.
In a short period of time.
But there's no law against
There's
that.
no law against it. And in the
That's
response,
what I'm saying.
And in the response from the respondent, they were stating they did what they were supposed to. That's what the house sold for. Everything was copacetic.
Yeah.
Right? That's what the argument was. But that's what the main crux of the argument was. And that they feel like they were taken advantage by the respondent in
They
the
didn't have
transaction.
but they didn't have an agent.
Correct. They were
And
unrepresented
the
in
respondent's
the transaction.
attorney pointed that out in his response or her response to you, correct?
Yeah, so they're unrepresented, and they stated that they didn't know that they were unrepresented.
But the
right?
personal interest should have come from the respondent, not the seller.
Well, the issue is
The unrepresented person.
well, I think the chief issue is the respondent wants us to build something for them to exonerate them, and I don't think it's our job to carry that water. I think they required to disclose in writing. They didn't.
Ta-da. So there could be $1,000 penalty for that.
1,000.
Can we not stick with the 2,000?
It's only 1,000 per per what? Violation. Unless, but now you can do it by the day, per day. But we don't know any per days in this
Council
scenario.
doesn't like it when we do that.
Preferably.
So you think 1,000 is all that we can do?
I mean, it is up to you to decide. I mean, so
I think 1,000 is legally all we can do because the other thing they provided. We gave them 2,000.
3,000 to start, right?
No, there was 2,000. One of them we're dismissing because, number 16.
Okay, so we're. I make a motion to have a civil penalty of $1,000 for violation of no personal interest disclosure.
Second.
But it's the personal interest, not the property disclosure that we're missing.
He said.
Okay. And DJ, you seconded that? Okay. All right. Any more discussion on that one? All those in favor say aye.
Aye.
Any opposed? That motion carries unanimously. Number 17. Okay, so this one was a Facebook ad, and I think that they were saying it was on their private page. We consider Facebook as advertising. So, the new information, what exactly was the, can you?
It was 1,000, then they dropped it to 500.
So here's the thing. I got a problem with somebody who violates and then they get caught and then they make the change. So they want us to not make the penalty. They already violated. Yes, we're glad they changed. They have to change. They have to fix it. That's required also in addition to the penalty. So that's what, and this one is one of those discuss also,
I make a motion to sustain our original decision.
which was $1,000 civil penalty. Okay, is there a second to that motion? Okay, we have a second by Mr. Moffitt. Any more
Question?
discussion? Yes, ma'am.
Does it matter if it's a private Facebook page and not?
The statute doesn't say anything about private pages.
So that's my question. Is there
They're still
sense that it was their person? Differentiate.
Facebook is advertising. Period. There's no exception for private pages.
If you're advertising a property.
That's my question. Is why do they think that that's an excuse?
Because they're trying not to pay.
I'm not to pay.
All money.
Never hurts to ask,
Yeah.
as my husband would say.
Well, that was my only question.
Okay.
Okay.
So my question about this is the complainant a part of that firm who's on this this firm Facebook page? Because I just don't get it's like, it sounds like they've got an axe to grind maybe with this person, but I'm part of a firm with over 1,500 agents, and we have a coming soon. We have a inner office firm page, and it's only by invitation only, where we, everybody on there is a licensee holder. And
Apparently that ad or whatever, it seems, leaked out from the private page onto this agent's personal page. And that's what's at issue.
I think it was in their group, and it was an inter office complaint, in that you could file a complaint against one of your fellow.
But because it leaked out from the private Facebook page to a personal page.
Well, the issue is there was a conversation in a private page, and the non-compliance is the page itself in general. But the thing is that the respondent is stating that this is not their personal Facebook page, it's just like a separate one. So it's not private. So they have two Facebook pages, and they're saying that their personal Facebook page is in compliance, but this is a separate Facebook page. But the complainant is part of their firm's group, and I guess there was a dispute within the group that they're saying what Commissioner Ferris was saying is what precipitated the complaint.
Wait, when you want to get that person out of your office?
So,
but also,
Go ahead.
I have a Joan Smith Facebook and a Joan Smith. So I could
Right.
Gotta look at.
And it looks like at the time that this was first opened and when we reviewed it for the first time, by that point the respondent had already removed it. So it wasn't after they received the consent order that they corrected it. And again, I think, I voted probably for the 1,000 penalty initially, but I would, yeah. I may have a substitute motion if this one, depending on how this one passes or fails.
Comments?
Call the question.
All right, we have a call for the question. We have a proper motion by Mr. Diaz and a second by Mr. Moffitt, and that was to keep the original. Is that correct? Mm-hmm. Keep the original $2,000 civil penalty, or one. Okay, so not to keep the original, but to change it to.
No, it was 1,000. Then when you change it.
Okay. All right. Is everybody clear on that? All right. All those in favor say aye.
Aye.
Any opposed say no.
No.
Okay. Raise your hand if you said no. 3 noes and 4 ayes. So that motion passes. Okay. On to number 18. I pulled 18 through 25 because they all were had to do with the same issue. And this issue was advertising on a billboard. And let's see. Did you have letter of warning on the principal broker only? Or you got letter of warning on everybody? Does that include the principal broker, Anna?
No, it's not.
And so the principal broker is number what?
Broker is number 18.
The first one, okay. So the new board and the new information is that they changed the sign, right?
Well, the new information was more of an explanation of as to what happened, but also this was just a re-review because this is a case that came to me from previous council too, and so it was an explanation as to what exactly happened with the situation from the billboard. And I know that the commission really does, we view advertising complaints and billboard situations as the fault of the principal broker when it comes to the areas and what is going on. But after talking to the principal broker at length as to what occurred here, it was abundantly clear to me that they went through several steps to make sure that this was in compliance, but it still was not when it went up. And then as soon as it went up, it appears that someone took a picture, and then 9 anonymous complaints were sent in. And then they were immediately taken down. And so after...
What was taken down?
The billboards.
All 6 of them?
All of them. All of the billboards were taken down. So it was a digital billboard, so it was going around. And so I looked at it and I didn't think that it was essentially... I didn't think it was right to assess a civil penalty to each and every affiliate broker that was on the digital billboard because of what happened, which I really do blame the billboard company for what happened here. But I do attribute still, I know that someone needs to be at fault as to what occurred. And so that's why I had made an amended recommendation to send the letters of warning to the affiliates and then the civil penalty to the principal broker as to what happened here.
Can you give us your reasoning on why it's a $5,000 civil penalty and not $1,000?
500?
Why it's a 500 and not 1,000?
I put it as 500 as it was a first time advertising violation.
And this principal broker has been a principal broker for how long? Because it's a new company.
Right. I can double check and see.
But that could have been their affiliate. All right. So here's the problem I have with it. It was a digital. When you said digital, that tells me all it takes is a call to Lamar, because we've had signs before. All it takes is a call to Lamar, and they, on their computer, stop that ad. They left it up for a month.
No, it wasn't up for a month.
No, they did that.
From
They did it
August 8th to
immediately.
September 4th.
What it looks like, they took it down immediately. Here's my problem with it.
Well, no, it says August 8th through September 4th.
Not new information.
My problem is if the broker did everything they were supposed to do in communication with the billboard company, and the billboard company still was in error, and then they caught it immediately. I just don't.
Where do you find that they caught it immediately and changed it immediately?
It says it in the response.
Under number 18.
Before
The new
boards-
information.
Top of page 18.
Before boards were ever live.
Well, how were there pictures of them if they weren't live? The billboards ran from August 8th to September 4th. Right.
Keep going down.
Like top of page 18 of 57.
Okay.
The new information.
It says they notified Lamar immediately. So I don't know that they were taken down immediately, but they notified Lamar.
How did they get the pictures though if they never went live?
Well, it doesn't say that. It says the third party went ahead and posted incorrectly. When we noticed,
So
They were also exchanging proofs back and forth with the company prior to it ever going live.
So Lamar posted the wrong.
Yes. So they were.
And they were up for a month. Well, in one place they're saying that, and in another place they're saying they never went live. How did the person who made this complaint have pictures of it if it never went live?
It doesn't say it never went live. It just says we notified.
Yeah, it does. It says at the
immediately.
top of page 18, before boards were ever live, our director of operations specifically mentioned it to Lamar.
But they went ahead and posted incorrectly. So it sounds like they were in communication constantly with the third party provider, and they did everything they were supposed to do to make it be in compliance.
I read those dates, August 8th to September 4th, as the runtime for the billboards.
It's
What
usually
they were
month to
supposed
month.
be, what it was
Yeah.
supposed to be. And all of these events are occurring within hours or that first few days of that run. Except the August
And again,
to
my
September.
problem is if the broker did everything they could possibly do, which it seems as if they did. And
No,
I
it was
would
the
assume-
director of operations.
Well, but it's the broker.
I would assume that you have documentation of this, Anna, that they did send correct proof. Yeah. I just have a hard time if someone else made the mistake to penalize.
Because we don't punish brokers for third party actions on a regular basis. If they're like if a listing is reposted on a third party site and it's not within the advertising guidelines, we don't go after the broker on that. Little grace here for that.
So why don't we have, can we do 18 through 25 together and someone make a motion for the principal broker, and at this point, Anna has asked for a $500 civil penalty for the principal broker and a letter of warning for the affiliates.
I'll make a motion.
Second.
Okay, is that your motion then?
My motion is to accept council's recommendation on 18 through 25 as is.
Second.
All right, and Mr. Begley seconds that. All right, ready to vote? Any more discussion? All those in favor say aye.
Aye.
Any opposed say no.
No.
No. How many noes? Raise your hand. All right, 3 noes. So that motion carries 4-3. Okay, now we're down to number 39, Ms. Smith.
Oh, I know. Litigation.
Yes, ma'am.
Oh, give me a little refresh. I just
In discussion with Ms. Matlock, because there are already cross suits going on, it would be a consent order for litigation monitoring that would be signed by the respondent, but it would be that I would check in occasionally with the court case that's pending in the other matter, and to see how that is resolved. This is a very complicated matter, and I just don't feel like it's appropriate at this time for me to recommend a penalty.
And typically, if something is, if they're found not guilty in civil court or criminal court, that's great information for us to know, do we keep going with this or not? So would you have a motion?
I make a motion that we accept council's recommendation.
Second.
Proper motion by Ms. Smith, and who over here did I hear? And a second by Mr. Moffitt, that we accept council's recommendation. Any other discussion? All those in favor say aye.
Aye.
Any opposed? That motion carries unanimously. Number 48. Number 48 was a lapse in E&O. This one is also Ms. Cooper's case. Okay, let's see here. You recommended a $400 civil penalty for lapse of E&O without backdating. Okay. All right, so this person was licensed. So they had a renewal. They've been on license for 2 years, and so they had a renewal, correct?
I believe so, yes.
Oh, I know what it was. Did we file a case against the principal broker in that instance, since this is an affiliate?
We haven't already. We will.
So then I would agree to the recommendation by the council, along with opening one against the principal broker, if somebody would make that motion.
So moved.
All right, so we have a motion by Mr. Diaz and a second by Ms. Smith to accept council's recommendation. All those in favor? Oh, excuse me, and open one on the principal broker. All right, any other discussion? All those in favor say aye.
Aye.
Any opposed say no. That motion carries unanimously. Number 57, Ms. Smith.
Other one, like it was a wholesaling.
Yes, ma'am.
Asked for
57 is, oh no, where are we?
57.
Okay, 57, okay.
Yes.
Age 43.
Okay, got it.
Yes. So this is where someone was selling property that they did not own. Is that correct?
Yes, ma'am.
They only own the paper.
Yes, ma'am.
Okay.
signed contract, which I still am not quite clear how those work, and so that would be part of the process. Yes, ma'am.
We got a interpretation from the Attorney General's office on this. Is that correct, Anna? On wholesaling.
We asked for one, but I don't think we got it.
Have we not gotten one? I thought we did.
You got an interpretation from me.
That's as good.
That's as good as gold. And what was your interpretation? Yes.
An owner. An ownership is required in order for it to not be considered like unlicensed activity.
So if you have an unlicensed person who says to some owners, let me sell this property for you, I will get some investors in and sell this property for you. That person is unlicensed, they're wholesaling, and that's not allowed. Correct? An unlicensed person will sell,
yeah,
negotiate with other
would be
people.
unlicensed
I just wanted
activity.
that on the record for a specific reason.
Well, hold on. Wait. I need some more context.
Okay, so you have people on this property.
Yes.
You have this person say, let me get some investors together and I will sell that property for you. That's unlicensed activity.
Do they own the property that they're offering to sell?
No.
Okay, so they don't fall in any
No,
of the
they're just wanting to
exemptions.
wholesale it for them.
Okay.
But a
It's
wholesaler
unlicensed.
typically works is that they have a signed purchase and sale agreement,
Yes.
which
Correct.
gives them some kind of interest. I don't know if it's an ownership
Right.
interest.
Yes. Yep.
Gives them no interest in the land though.
Yeah. Picking up what you're putting
So
down.
they have a
In
sheet
the
of
paper only.
So they're selling the contract,
Yes.
not the property.
Correct.
And that's where the wholesalers are. And is that unlicensed activity, which is, I guess,
We really shouldn't be doing that. Correct. We should have an ownership interest in the property, which usually comes in the form of a deed.
Yeah.
so it's but this is good information. So
Yeah, we agree.
So you have to have a signed purchase sale agreement. You have to go to the closing table. It has to be signed. It has to be recorded with the register of deeds, and you get issued a deed in your name. And that's your
Then
ownership
you
interest.
can sell it.
Right. You need to.
You need to have a deed. That's what's communicated.
Or you can have a real estate license.
Or a
You can have a
license.
Right.
Okay.
And not somebody that had one 10 years ago either. What'd you say, DJ?
That's the best explanation I've heard of in 3 years.
Okay.
I've been here.
All right, so
Now it's clear to us.
I move to accept council's recommendation.
Okay, is that one? Okay, what are we on? 57. All right, Diaz, and seconded by Miss Smith. You made that. Okay. All right. So we have a motion to approve council's recommendation on number 57. All those in favor say aye.
Aye.
Any opposed? That motion carries unanimously. Yes, sir.
Or Ms. Matlock, what kind of success do we have in collecting fines when we find people that are not licensed? Zero?
It's not zero.
Okay.
It's not high, but not zero.
And a lot of times they go on to get a license because it's usually the people who made an honest mistake.
Well,
who will go on and get a license? Well, once you're fine, that should get your
Our fine
attention.
is not to a non-licensee is nothing more than a piece of paper we're trying to collect $1,000 on. If I'm a person out of state, if I just tear it up and throw it in the wastebasket, what do we do?
Well, let's put it into like 3 categories.
All right.
Okay, the categories of, we have unlicensed people that had licenses and they
Okay.
lapsed.
Right.
That's pretty high. We usually collect on those.
Right.
We have a category of individuals that didn't really know that they were conducting unlicensed activity, as Commissioner Franks was stating. that one's like 50-50. That they're like genuinely, oh, that's a mistake. I'm sorry I did that. And then we have a category of people that are like, I really truly do not care.
Right.
And then, that's pretty low.
That's this person in 57 probably.
That one's probably going to be a little bit difficult for us.
Okay.
So
But we don't care just because, people get put in jail every day and
Right.
they're not reformed in
Right,
jail
right,
and they
right.
come back out.
Okay, I have a question.
Yes.
If someone is advising sellers on real estate matters to the point where they are telling a seller to tell their agent to price it like this and don't do this and do this and advising them how to advertise their property, but they're supposedly not receiving a fee. What's your interpretation?
Well, are they receiving valuable consideration? That can be as small as a mustard seed.
I'm with you.
What we learned in law.
Okay.
So the statute states when we're talking about unlicensed activity, or like or the definition for broker, it talks about receiving a fee, commission, finder's fee, or other valuable consideration. So valuable consideration might not be a fee, but if you're receiving, business referrals, could be considered valuable consideration. I bet they're receiving some kind of valuable consideration for doing that. And, advertising does fall into 301, which is prohibited activities that require you to have a license for unlicensed activity. So I would advise that person likely to refrain from such activity.
I'm sorry.
Your microphone.
Are they is that some that's doing it to just one particular listing or like lots of listings?
Several sellers.
Okay.
There's also, it's easier to get forgiven than permission. So I think a lot of people work with that kind of understanding of, the next one was number 64. And after conversations that we've already had today, I would like to agree with council's recommendation if somebody would make that.
So moved. Second.
So we have a motion from Mr. Diaz and a second by Mr. Moffitt that we accept council's recommendation on number 64. All those in favor say aye.
Aye.
All those opposed say no. Motion carries unanimously. Number 69, and this is with Ariel Carter. Okay, 69. Just did 64. All right, 69. Okay. Yeah, that's what I have written down here. Failure to supervise. You can't have an administrative complaint open, then the principal broker fixes it and not be penalized. So this was opened administratively, obviously, off of a complaint from an affiliate or someone else. Let's see. So they're saying they fixed it, which means it was wrong. But with I think with Miss Carter, from hearing some of the discussions that we've had today, that you kind of see if somebody does something wrong, we're not, and then they fix it, we're not for letting that go. So I was wanting to find the principal broker guilty of failure to supervise on this advertising complaint. Does anybody else have any other opinion on number 69? Anybody like to make a motion?
Move that we assess a $500 civil penalty on the principal broker for failure to supervise.
For a second?
Second.
All right. We have a motion to assess a civil penalty of $500 on the principal broker here, made by Commissioner Diaz, seconded by Commissioner Moffitt. Any other discussion? All those in favor say aye.
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 Any opposed? All right. Huh? Okay, so that is a 7-1 vote with Mr. Ferris voting no. All right, number 73.
I did that one. You may have done it also. You may have done it also. 73. And my question was there a personal interest form? Do you have a record of that?
There was, yes.
There was.
By all parties.
Motion would be
Right. Council's recommendation was to dismiss. All right, so we have a proper motion by Ms. Smith and a second by Mr. Diaz. Any further discussion? All those in favor say aye.
Aye.
All those opposed say no. Motion carries unanimously. We have two more left. Two more. All right, number 74, Ms. Smith.
look here just a second to make sure. Okay, this was one where Honda was not aware that they had entered a written contract. Is that correct?
Correct, yes.
Because there was an issue of acreage and division of property, and would you explain just a little bit?
So in this situation, the original complaint was that they were saying that the respondent was selling something that they didn't have access to. They put in the incorrect address, and then they also had an issue with the amount of acreage that they were advertising. The Clayton said it was supposed to be 14, but all the documents I've received and looked at was 16.11, which is what the respondent had, and all of the things that they were advertising. The biggest problem that was concerning to me was that in reviewing everything, the respondent tried to say that they were not in any kind of written agreement, although they had an offer acceptance, and they were very clearly entering this agreement. And there's tons of documentation from both sides showing that they intended to sell this property. Additionally, the respondent put in the incorrect address for the property that they were trying to sell, and it wasn't corrected until the complainant brought it to their attention, and they just essentially had no knowledge.
Oh, the affiliate broker, I'm understanding, made several mistakes on the contract to purchase.
The main one was just the address for the place to be sold. It's a big one, yes.
I was confused.
Well, they thought they were getting 16 acres and they only got 14.
Well, that part I'm not confused on.
I knew you'd catch that part.
My part is the first sentence. It says the complainant is a Tennessee resident home buyer. The respondent is affiliate broker served as the complainant's agent. So this respondent is the agent for the person making the complaint. And somehow there was a contract written, and this respondent in paragraph number 4, the last sentence, didn't know there was a contract. They're their agent.
Didn't know their name.
Something's just weird.
It was very weird. In the response, he made it sound like they just were unaware that there was any kind of communication between the two.
Have a written contract.
There is a written contract, and
Binding
there are
contract.
signatures from different parties. Just the response made it sound like there was no communication.
Was there
It
a
very weird.
correction made with a new contract showing
Yes.
the
Yes, there was a correction made with the new contract.
Was it a new contract or amendment, or how was that?
They just changed the address. It was-
Just wrote across the contract.
they deleted it and submitted a new contract.
And initialed it?
It was a completely different one. So
That's
decided-
completely different.
Yeah.
So your letter of warning would be failure to exercise reasonable skill and care.
It was a letter of warning for that, yes, because eventually the buyer did not feel comfortable with this agent and backed up the deal completely. So there was no completed sale. Yeah.
He add education to this.
Yeah.
What would you want the education to be in?
Out of the letter of
Contracts or
warning.
what?
What did you
So
say?
we can't do it with just a letter of warning. We have.
You can't do education without a civil.
Can you not do education with a letter of warning? You cannot. So it has to be a civil penalty.
No, it doesn't have to be a civil penalty. We can do a consent order where you just ask them to do education. It's just if we're asking someone to do something, it has to be an offer of it has to be in the form of a consent order. So you don't have
Or you can still do that. And I always think education is better than a monetary penalty on anybody, really, any time. I would rather they learn to correct their mistakes. What kind of class do you think they should take?
You need a contracts class.
And how many hour
Or-
contract class?
How many hours, Mr. White, would a contracts class?
Generally, Commissioner, they're 4 hours.
My recommendation, minimum. Does not count.
120 days or 180 days.
Typically do 180 days.
180 is fine.
Okay.
All right. So that's your motion, Ms. Smith?
Yes, yes, ma'am.
All right. And we have a second by Mr. Diaz for a 4-hour contracts class. Okay. Clear on that one? All right. All those in favor say aye.
Aye.
Any opposed say no. The motion carries unanimously. And the last one is number 76. Okay, Ms. Carter, this one is just like that number 69 one that I had, where they did not respond until, no, it's not just like 69, excuse me. This one did not respond until the second complaint.
Return to the first complaint after the second.
Okay.
Say that one more time.
There was an original complaint. They responded to that one on behalf of their agent, but this one they did not actually respond to.
Okay, so, and the new recommendation was to discuss. That's what it is. Okay. Is that correct?
It's for dismissal.
Dismiss.
It changed it, but based off the
76.
conversation of today.
Oh, I see up there. Okay. So tell me the timeline here. It was an agent didn't have their E&O, and so we opened administratively against the principal broker, correct?
This one, but in the original complaint against the agent, the principal broker responded on that agent's behalf, essentially saying that they weren't aware of the advertising violation and they had since fixed it, which is what my recommendation was to dismiss it originally. But based off the conversation of today, I'll probably change that recommendation going forward.
What would your recommendation be?
76.
76.
Yeah. For this one, since they didn't respond in like $1,000 civil penalty.
No, their history was they had an E&O penalty. All right.
So you recommend $1,000?
Okay. Somebody like to make that?
I'll make that motion.
Second. All right. We have a motion by Ms. Tolbert and a second by Mr. Moffitt that we assess a $1,000 civil penalty for. Was this failure to supervise?
Yes.
Yes. Okay. All right. Any discussion? All those in favor say aye.
Aye.
Any opposed say no. That motion carries unanimously. All right. So that completes the legal report. And now we're on to commission discussion on the Sunset Law and Open Meetings presentation.
I think we were told that we're not allowed to huddle up anymore.
Who's making that presentation? Miss Anna, do you have a slideshow? Oh, I knew you would.
Oh, joy.
I want to say, too, that Anna and Caitlin and Ross are highly thought of at Arello, too, because they have been they go to every meeting and they are involved in it too. So I appreciate that from them.
I did remember.
Okay. First of all, I would like to extend my apologies to Commissioner Ferris, as this will be a bit longer than he is in.
Now he's rolling his eyes.
But this is required for each of our boards and commissions per year. So this presentation, we're going to go over the Open Meetings and Open Records and Public Meetings Act. Each of you, we try to do this once a year, but we haven't done this in a while. And so I know we briefly go over this information during orientation, but we are going to go for some additional information here now. So here's our disclaimer. I'm not going to read this verbatim, but generally this is just to let you know that the information that we're giving you is general guidance on the matters that we've provided about the rules and regulations, and that we are not providing general like legal advice. So this is just going to be, we've tried to be as complete as possible in the information that we're giving, but you should not use this as a substitute for consultation with your professional legal or competent advisors. So if there are any questions that you have related to the Public Meetings and Open Records Act, please reach out to me, and I will be able to help you as best as possible. So the Open Records Act, this is the statutory citation where it can be found. So what is included in open records for a board or commission? So on the left, you're going to see what is included and what is not included. So we have documents, media, electronic data, processing files and output, other materials, and anything that is made or received pursuant to law or ordinance in connection with the transaction of business by any governmental entity. So anything that we look at or review prior to the board meetings, that is considered a public or state record. So the legal reports that we look at, those are considered public record. Our license files are public records. The meetings that we look at, those are public records as well. What is not a public record? Devices or equipment where the records are displayed. So the iPads. But just generally speaking, anything that we provide you is considered to be just assume it is going to be a public record, which means that if someone was to request that information, it can be disclosed. Next, we'll go over to the Public Meetings Act. So this is generally the areas that we're going to go over the introduction. What is the Public Meetings Act? What is a meeting and what's not? What is required for a meeting covered by the Public Meetings Act? We'll go over notice, agenda, public presence, and minutes. And then what if the board violates the Public Meetings Act? So here's the definition of a Public Meetings Act. It is to be the policy of the state that the formation of public policy and decisions is public business shall not be conducted in secret. So essentially, as we state, everything is done in the sunshine. So this shall not be construed to limit any of the rights and privileges contained in the Article 1, Section 19 of the Constitution of Tennessee. So, this is general information, case law that we have related to the Public Meetings Act. This is, I don't think you really kind of need to go, I'm not going to go into too much depth related to this. in general, but it is broadly to promote openness and to protect the accountability in government and to protect the public against closed door meetings at every stage of the government's body's deliberation. So generally speaking, we want everything to be done in public and in the sunshine. One of the goals is to have an open and transparent government. So, all meetings of any governing body are declared to be public meetings open to the public at all times, except as provided by the Constitution of Tennessee. So, all of our meetings that we have here at the Commission are open to the public at all times. So, any of our meetings, people can attend. That's why we post notice. Anyone is able to attend the meetings. None of our meetings can be held behind closed doors. There are a few exceptions. We'll cover that. And there's like one exception. We'll cover that. But all of our meetings are to occur in the public. This gives a definition of what a governing body is. Essentially, it's two or more members that are making authority or decisions and recommendations on public policy or administration. So this applies to all of our boards and commissions here at the Department of Commerce and Insurance. So, what is a meeting? A meeting is the convening of a public body, which a quorum is required in order to make a decision or to deliberate toward a decision on any matter. Also, committee and subcommittee meetings are included. So this board doesn't have committee or subcommittee meetings, but some of our other boards and commissions do, and so those are considered public meetings as well. And so that means that those meetings are to be open to the public, noticed on the website. Everything is to be available. But this means that anything that happens when there are two or more people of the board meeting together, that's considered a meeting. So whenever you guys receive our board materials, you'll see that our emails are blind copied, because if an email with more than one board member is contained, that's considered a meeting, and public notice is to be required, and individuals are to come to that. It is considered to be a meeting because we're convening and discussing board business.
Is the one exception executive?
Yes,
okay.
Executive session would be one of the exceptions to the Public Meetings Act.
Okay.
Any additional questions?
I would say, as far as that, in my 10 years, we've only done that a couple of times, and it usually had to do with an HR problem that, so that's why we had executive session, and that the lawyers all handled it for us. And
right. Also, there may be a time where the board may need to have executive session if there's something related to ongoing legal matter. So if the board is in anticipation of litigation, then executive session will be called. That means those executive session is not open to the public. However, the format of executive session is very different from board meetings in that it is led by the attorneys, and the attorneys are the ones that dictate the meeting. It is more so us giving you information as to what is going on and providing that information. There's not so much as a dialogue and group conversation. It is more so facilitating and providing information as to the topic that's going on. So what it does not include any site inspection or project or program. So inspections of that more so relates to probably our public records requests. So public records requests, individuals are allowed to come to the department and inspect our documents that we have and are available, but that is not considered to be a public meeting. So inspectors cannot, in conjunction with the inspection, deliberate towards a decision. So here are examples of things that do not consider or not considered public meetings. So it does not include a chance meeting of 2 or more members of a public body. So that means if 2 of you were to run into each other on the street and meet each other, that would not be considered a meeting, a chance meeting. So if you were to like accidentally run into each, that's not considered a meeting. However, in those situations, you are not to decide or deliberate public business and board business at those times, because we don't want to violate the Public Meetings Act. And so on the side, those are just some examples of some cases that discuss further. Also, what is not included, 2 or more members of the public body may share a meal together in which the public business is not conducted. So discussions, again, should not include deliberations. So the dinners that you have together beforehand are not considered a meeting. Just a reminder, as you all know, those dinners are to be not include any of our board business that we talk about. So we want to make sure that we are keeping those discussions about literally anything except what we're talking about our board business. So
Station that's pending board business, but if we're talking about stuff that occurred in earlier meetings, that's already part of the public record. Is that?
Let's not talk about board business.
Okay.
I get that. Can I leave?
Huh?
I get that. Can I leave?
No.
Just kidding.
You're still here.
Just kidding.
So you guys are able to, you can go to dinner, you can play golf together, go church together, but do not discuss, deliberate, debate, or have any kind of board discussion outside of these meetings. So that even includes during breaks. During breaks, we're not talking about board business. The only board business discussions happen when we're on the record, sitting in these chairs on these microphones. Okay, any questions? I know there are no questions because we follow these rules all the time. As I was saying, includes lunch breaks, smoke breaks, recesses between morning and those things.
So as for instance, this meeting is not over until tomorrow. Okay? We have a hearing tomorrow, and so we will reconvene tomorrow morning. So tonight we can't be guessing about what's coming before us tomorrow.
Right. And I have eyes everywhere.
She does.
So, regular meeting and special meetings all also count as meetings. So this includes like emergency meetings. A couple of you have been there when we have emergency meetings. Those are still noticed and the public is still permitted. Exceptions would be, as we talked about, executive session. Executive session is not required to be noticed, and those are again also not public meetings, but that is like the only exception to the Public Meetings Act. So this is an example of executive session. It occurs when one or more board meetings meet with the board attorneys and the board is under threat of lawsuit or has been threatened with suit, and the members ask their attorneys related to such questions. That's it. That's the subject, and that's the box in which we live in executive session. Also, it can talk about specific HR issues, but you're only asking questions related to the lawsuit to the attorney at that time. So the attorney is facilitating that conversation and we're providing the information and you're asking questions about the suit specifically. No other conversations related to board business are included in that executive session. So all of that, if an executive session was to occur, those guidelines again will be outlined and explained, but that is the parameters of executive session. So, as we know, do not deliberate about any specific matter before or potentially in any executive session. So how far does it go? So oral interviews that were conducted by the Civil Service Commission of the Maury County persons applying for jobs within the classified service of the Maury County Sheriff's Department do come within the provisions of the Open Meetings Act. So, for example, if we were to be interviewing somebody for an executive director's position, we would have to do that on the record. So this is a good example of that here. So these are example about member emails. So if the chair were to email, here's a news article or something I'd like to include in the next agenda, that's fine. But this is not something you email. Here's a news item about one of our licensees we should consider for revocation. I never want to see one of these emails. So that's not an email that you would send. But also remember, when you're emailing, you're only emailing either the executive director or you're emailing me or both at the same time. So, like, for example, Marcia, I know, sent us a copy of a news article related to a specific entity and something that was going on related to an ongoing legislative matter. That was fine. Had nothing to do with the particular licensee we should consider for revocation. Or if there's something related to agenda, that's fine. But if it's related to specific individuals, we want to refrain from that.
And I will say that I did have one occasion where the Franklin Police Department called me and wanted to let me know about a person who had been indicted that day, and they thought that the Real Estate Commission should know about it because the person was a real estate person. And so in my head, I thought, I'm not putting that in writing. I'm calling Caitlin and see what and actually Caitlin and our attorneys were already on it. They had already heard. So there's sometimes you don't even want to put something in writing. Pick up the phone and call if it's something major.
Right. If there's something that you're confused about, always ask a question. For our purposes, it doesn't really work well to ask for forgiveness instead of permission here. So, again, if you're emailing our counsel, I have a question about legal consequences of something the commission has done. That's an okay question, but not, I've taken action as a commissioner and now someone is upset. We're not taking unilateral actions as our own, but we all know that. So, another email, another commissioner. If you send a quick email or call another commissioner, that is not a chance meeting because you decided to call that person. So, even if you don't discuss board business, it's really not a good idea because it has like a chance of impropriety. So, let's just generally not do that. So, that would not be covered under the Public Meetings Act.
All other commissioners. Or friend.
What if I wanted to rent his condo?
What if you wanted to tell me traffic was bad and not?
That has nothing to do with commission business, though.
Yeah.
It ought
to be.
So it is like, obviously, it is not, we know that it's not something that you can do all the time. Like, so if there's something that you need to be in communication with another person, that is understandable. But Joe, you can't call DJ every day. So I understand that, like, you're friends, but you also are individuals on the commission. And so if it doesn't look great. Does that make sense?
So sometimes West Tennessee heads home, traffic, and whomever's in front, they'll call the other two behind and say, you need to divert.
It's always Joan. Joan's in front all the time.
I got it in front.
It's a race. It's a race.
Y'all need to get waves.
So
I
are
mean,
you,
Anna driving me heavy. She can call you.
yeah. So you're saying that we should avoid those conversations.
But I'm saying, like, the frequency of those conversations should be minimized as much as possible. So if it is around if you're having a conversation related to traffic around the commission meeting, that is fine, but I don't think you should be engaged in conversations daily.
We're good, boys.
There used to be a commissioner that the minute I'd hit that road right there, headed home, they would be calling me, wanting to go over everything that we talked about today. And can you believe, and I'm like,
that is a blatant violation of the law.
Yeah. And I had to tell them a couple of times, don't do it.
Okay, so this is talking about electronic attendance. If one of our members cannot attend the meeting in person, the absent member can participate telephonically, and the meeting, but all the votes have to be roll call votes so that the public knows how any commissioner is voted on each issue.
We also, we cannot have quorum that way though.
Right. So if, for example, since Kathy is not here, Kathy could vote and her vote would count, but it would not count toward quorum. So if we have 4 people in person and 1 person on the phone, we don't have quorum and we cannot meet. Also, another thing that I would like to mention, you want to avoid conversations via text message and email with other individuals on the commission, especially because with the Public Records Act, your information is subject to disclosure with the Public Records Act. So if someone were to request that information, we would have to turn it over. So keep that information in mind.
Over being the phone.
Your messages, yes.
Messages that
You do violate the open records law or the sunshine meeting. Start discussing via electronic communications. Any board information or board business.
Right.
You are therefore opening up your personal communications are now records of the commission. And so we would have to disclose those if there's an open record request.
Correct.
So
keep that in mind.
Yeah.
They fill out a request and you present everything that you've ever talked to anybody.
Right. Yes. So that's why you ought be avoided.
We'll put anything in writing.
Also, don't do it on the phone.
We'll just copy Ann on all our stuff from now on.
That doesn't always.
On the way home.
That doesn't always work. Okay. So we were just stating, yes, a person attending electronically does not count toward quorum, so we must still have an in-person quorum is still required for our department policy. That's what this slide states. So the act is construed most favorably to the public and is all encompassing. So it applies to every meeting of a governing body except where on the statute on its face it excludes its application. So when a question is when something is in question, it is going to defer to disclosure to the public. So that is where the burden is going to shift us to prove why we would not want to disclose that information. And that is going to be something it's going to be a high burden for us to accomplish to prove why we would not want to disclose it. So that is something to keep in mind. Also, this talks about attendance. So the public has the right to attend and observe your meetings, but not necessarily the right to participate. But the department does permit public comment so long as the comment is not disruptive of the flow of the meeting. So that provide below just gives some examples of public comment at our meetings. I'm not going to read through those all the way, but that's just generally our department policy. So you'll see on our agenda sometimes where individuals have requested to be placed on the agenda. So just know that the public does have the right to attend, but not always has the right to participate.
And who makes that call? Who gets to participate and who doesn't?
Actually, we might be updating you on that. There may have been a statutory change since this came out, so to be continued. So this talks about adequate public notice. So adequate public notice of the meeting, there's a 3-pronged test. It says that the contents must reasonably describe the purpose of the meeting or the action proposed. So that information is provided in our meeting notice in our agenda, as you'll state. The second states that it has to sufficiently in advance of the actual meeting. So our meeting agendas are always posted the week before the meeting. If you notice on the website, that information is provided. And then the third one is posted in a location where the community would be aware of such notice. And so our agendas are posted online on the Real Estate Commission's website. So example would be internet, newspaper, and bill posting, but we have the notice that's provided on the website. So those are the ways that the notice of the meeting has to be provided. So this is again talking about posting the information online to make sure that notice requirements are provided to the public to make sure that they're aware of our meetings. And so this states that our usual practice is to provide it on the board's website and the department's website. So the penalties for the violation of the Public Meetings Act is nullity. So that means that the effects of whatever occurs has been voided. It is null. So that is the reason that we make sure that we are in compliance at all time. So it is very important to ensure that we comply with the Public Meetings Act at all times, because we make very important decisions, and nullity is not something that we can really overcome. So that is the legal effect of the violation of this. So the Public Meetings Act is to make sure that our business is conducted in a way that's accessible to the public, and it applies to you as an individual member and collectively as a board. So we want to make sure that we let the sunshine in. And then this gives just another, again, the overview of how these apply to regular and special meetings, committee meetings, subcommittee meetings. The only exemption would be the executive sessions. And again, that's where you're asking your attorney questions about the legal issues at hand. And then we are required to give adequate notice. And if you violate the law, any violative acts are void, and also costs of litigation may be assessed against the board, and we don't want that to happen. So, who remembers NC Board of Dental Examiners versus FTC? Jeff, you want to give us a background summary of decision and implications in Tennessee? Okay, I'll do it for us, no problem. So this is talking about, so what happened was the NC Board of Dental issued 47 cease and desist letters to non-dentists related to teeth whitening. So the FTC filed a complaint that stated that they were violating the antitrust laws, and by essentially they were a state actor that was telling non-dentists to stop providing services. And so the board argued that they had state action immunity, but the FTC ultimately prevailed, and they did not have state action immunity. So the Supreme Court stated because the board did not receive active supervision by the state when it interpreted the act as addressing teeth whitening, and when it enforced that policy, issuing cease and desist letters to non-teeth whiteners. State agencies are not simply by their governmental character sovereign actors for purposes of state action immunity. Immunity for state agencies therefore requires more than a mere facade of state involvement, for it is necessary in the light of Parker's rationale to ensure the state's accepted policy accountability for anti-competitive conducts they permit and control. So, and what is required for now is that active state supervision. So it is required, it doesn't require that this is done in an active day-to-day manner, but whether the state has provided different mechanisms to provide realistic insurance that the board is protecting from anti-competitive conduct, that promotes state policy instead of the party's individual interests. So we want to make sure that we are promoting the public policy and not being protective of the industry and keeping other individuals out. So when we have those conversations and we're talking about individuals that are outside of the market, we don't want to make sure that we're being prohibitive of letting other persons into the market. We want to make sure that we are, again, being protective of consumers, but we're not wanting to bar those other individuals that are not necessarily required to be licensed from having the opportunity to still operate their businesses if they're not required to do so. So if we're ever, trotting down those territories, that's why sometimes I'll have you navigate away from those conversations, because we want to make sure that we're staying in our same kind of tract of where we're supposed to go, if that makes sense. This board is pretty good good about that, but we want to make sure. So in this particular instance, who's the supervising official? So the commissioner or chief executive officer for the department under which the regulatory board operates. So the supervising official, we have a policy director, and we also have the commissioner overseas. So we enacted in response to an NC Dental TCA 4-4-1265, and because of that, we have several mechanisms that are put in place to make sure that we don't allow the same thing to occur. So we make sure that includes that our policy director watches all of our board meetings to make sure that we're not looking at any decisions are considered to be like anti-competitive, and then there are other mechanisms that are decided that occurred. So of course, me as the board attorney, I'm always on the lookout to make sure that we're keeping on track in those decisions. But if something were to occur in that situation, we do have other mechanisms in place. If a decision was made, there's the ability for the board to hold an emergency meeting and essentially overturn the decision. But also, if all things fails, the commissioner of the department does have the ability to veto a decision of the board to make sure that it does not become an issue. So this is again just kind of outlining what is required under our statute in response to NC Dental. So it requires to give the board within 10 days that the action is subject to full review, and then review the evidentiary record or direct regulatory board or other persons involved, then conduct a review on the substance of the matter, in writing, approve the action, remand the action, or veto the action, as I just stated. So that's the end of my presentation. If you have any questions, I put my email back up there and direct line to my phone. If you have any other questions, please feel free to reach out to me. Thank you.
Great work. Thank you.
Okay, so Ms. Maxwell, do we have anything else?
No, I just want to say thank you so much to everyone. I have really loved working with each and every one of you, and obviously everybody at the department as well. So I think of the word bittersweet coming to mind. I think whoever okay. You just made me lose my train of thought.
Bittersweet.
Anyways, bittersweet. Yes, it's certainly bittersweet. And I've been at the department now for 8 years, which feels like forever. I feel too young to be here 8 years. But anyways, thank you all so much. And now I think Mark would like to say something.
Mark Green. We've missed seeing you, and we're glad you're doing better. Good.
Just wanted to, obviously we have 2 departures. We wanted to acknowledge and thank, first of all, Caitlin. We so very much appreciate you and what being able to work with you over the past several years, and you did a really good job, and we are going to miss you and appreciate you. And then, of course, Madam Chairman, I guess this is the last meeting that you'll be presiding over the commission. And like I said, when we said goodbye to Chairman Grease, we really appreciate everything you did, and working with you has been a real pleasure. And I know we've had some cases and matters that have come before us that have been kind of sticky, and we've had to work through, and you were always so professional, and we really appreciate everything that you've done, and legal is going to miss working with you as well, and we just wish you the best of luck, and hope we'll still get to see you every now and then. So
thank you
very much.
Well, so I have to tell you, there's been so many times that people have seen things in me that I didn't see in myself throughout my whole life. I've not really had any lofty goals at all, really. But in 2014, Grover Collins called me, and he and I had been president of our associations at the same time. Grover is from Lewisburg, and he was a commissioner, and he was going to be going off the commission. And he was a good Democrat. Governor Bredesen had appointed him. but we had a Republican governor, Haslam, and he said, so we need to get a good person in there. And he said he thought of me because he knew I was a good Republican. So, if Grover, when he's told me, you should apply for this real estate commission. And I'm like, Grover, I've only been up there one time, and that was to speak against something. And, I was scared of those people up there. But he encouraged me, and I did it. And I was very surprised that Governor Haslam did appoint me, and he appointed me twice. And it's enabled me to be with some really fine people. I had to make a list because I'm getting pretty old. When I came on, Bear Stevenson was the chairman. I don't know if y'all ever met Bear, but and Grover was on. John Grease was the assistant chairman, was the vice chairman. Austin McMullen, many of you know him. What a great guy he was to serve with. Wendell Alexander from West Tennessee, such a good, fine man. Gary Bloom from West Tennessee, loved and learned a lot from him. Janet DeChara from West Tennessee. David Flitcroft was a public member from Knoxville, and he was an attorney and did a great, great job. And then Fontaine Taylor, Bobby Wood, Diane Hills, and Rick Douglas. So what this has enabled me to do is to have not just fellow commissioners, but lifetime friends. And so that's what I'm hoping I have with all of you.
You got it. You got it.
I've really enjoyed it. And it's been an opportunity of a lifetime. So always do what's right. It'll please some and amaze the rest. Thank you all.
Thank you.
Okay, so tomorrow we reconvene back here at 8:30, and I know it's going to be a little different and new for some of you, but we'll have our legal team here to guide us, and we'll have a judge and a stenographer here. So just be here at 8:30 on time. We do know the judge is coming at 8:30. Okay, there have been occasions when that maybe didn't happen, but. So, did anybody else have anything that you want to say? We'll just reconvene tomorrow, so we're not adjourning today. Anything? Okay. Okay.
As a special thank you
Oh my
to
God.
Marcia. And because we know what her favorite color is, we want to say thank you.
Oh my God. That's a really big bag.
It's a Tiffany's bag.
It's a Tiffany bag.
It's your color.
Thank you, Joe.
Well,
That's from all.
Oh, that is so sweet, y'all. Okay, so we're gonna adjourn for now. And thank you to the people who came today, including my daughter and my grandson. And then, and we want to get a picture before everybody leaves. And I'd like to have it with our legal team also. And if we could just take a picture real quick. Brianna, will you take the picture for us? And then I'll open up this. Maybe in one, but.